Yes, yes.
Lordship, I beg to mention for listing a bail application, madam, filed on 23/2/2025. Um, maybe taken up on Friday, madam.
I don't know. Second of March. Second
Monday.
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 What's it?
Type legal lordship. I beg to mention for listing of regular bill lordship. Kindly fixed on Friday lordship. Lordship is the behind the bars lordship. Today 58 days lordship.
5th of March.
Lordship he is the behind the bars and today 58 days lordship.
Under what section?
Today?
305.
Today?
58 days lordship.
58 days.
Yes, lordship. Under section 305.
60 days.
60 days.
60 days.
Okay, tomorrow.
Lordship,
Tomorrow.
tomorrow. Friday lordship.
He wants Friday.
Friday.
Friday lordship.
Today is Wednesday.
Yes.
So you want on Friday?
Yes. Lord.
Okay.
Okay.
May please, Lordship. Lordship, I beg to item number 25, Lordship. Lordship, maybe on next week, Lordship. Actually, my TS Hazigan, my senior counsel is not available, Lordship, on next week.
Okay, on the prayer of so and so, let the matter be listed listed on 9th March.
Okay.
Next is your lordship. Your lordship, I beg to mention item number 36, your lordship.
Item number
36,
36.
your lordship.
36. Okay. CD not there. CD not received. Let the matter be fixed on
Interim is there, my lord, on 12th of March.
12. Interim order so passed shall continue till the next date of listing.
Your lordship, much.
I beg to mention item number 54, Lordship. Kindly adjourn the matter.
54.
54.
Okay, on the prayer of the learned counsel, appealing for the accused applicant,
Can
the matter is adjourned for the day. Let the matter be listed on 13th March,
Lordship, 9 or 10? 10 maybe.
10th March.
Muscle.
May it please the lordship, I beg to mention item number 14.
Item number?
14, 14.
Hmm.
Case ID was called for, it has not been received yet.
CD not received.
14th
Let
CD not.
let
No, no,
the
no,
matter be fixed on 12th.
12th, my lord. 12th.
Interim may be continued.
Huh? Interim order is there. Interim order is there. It's a
This
bail
CD
application.
No, CD.
CD is there.
CD not available, my lord.
CD not
No,
received.
yes,
so-
search it for me there. I am sorry, my lord. Item number 14, yes, 3556. Search it submitted, my lord.
So CD submitted.
Because of that.
So let the matter come.
Lordship, I beg to mention a listing of a bail application for motion for tomorrow, lordship.
Tomorrow not possible.
Lordship is behind the bar for 120
Friday.
days.
Friday.
Friday, okay, nice.
Friday.
Lordship, mention for regular bail application listing, Friday or not?
Friday, lot of matter has been fixed. Second.
Just the
Second.
TCR would be called, your Lordship.
Second.
In respect of item number 42, Lordship, another bail application was heard and disposed of by court number 23.
Court number 23.
So this has to be listed before the appropriate bench, Lordship.
42, no?
42.
42.
42. Heard, Mr.
R. Bora, Lordship.
R. Bora, learned counsel, appealing for the accused applicant. He submits that another bail application arising on the same FIR has already been disposed
Lordship.
by a coordinate bench. Let the matter be listed before the appropriate bench.
One can be a.
By the same, your worship has dealt with this, that 47 on the same footing, my lord. The lordship's order is page 30.
Oh, wrong, yeah.
Yes.
But she is the person from whom this all these things have been
There is
recovered.
a wife of my lord, one of the male culprit who is, my lord,
Was one about the 47 I also. Your Lordship, kindly see page 17.
Yes, my lord, not there, my lord, I have.
Yes.
Hmm?
That's total, my lord, 7 persons arrested on the same day, my lord. And out of this, 3, 4, 5 already granted bail. On the ground of, my lord, page 40, page 26. Page 26, 27, your lordship. Signature of the accused is not there. On the same ground, my lord, your lordship, yesterday, they will be yesterday also, your lordship, but to orders, my lord.
Okay, we'll pass an order. We'll pass their order. Similar order has been passed. Yesterday also
Yes.
one matter was passed.
Obliged to.
So here also, I mean, nothing is
My
there.
lord, yes, I have checked, my lord.
It will be disposed of, huh? In terms of the earlier order.
May I please, my lord? My lord, FIR is on case 10, my lord. It is registered under section 103, my lord. Allegation is that, my lord, both the petitioners murdered their adopted child, my lord, who is the age at about 3 years, my lord.
Okay, we'll issue notice.
My lord, 73 days, my lord. Short date be given, my lord.
Hmm?
73 days behind the bar, my lord. Short date be given, my lord.
Heard Mr. So-and-so, the learned counsel. Then is an application on the so-and-so. The case relates to alleged killing
Law
of
9.
the adopted child by the accused adopted child by the accused applicants. Call for the CD, let the matter be fixed on. Mr. Parasar, when?
My lord, on 9.
Ninth.
My lord.
Motion AB, item number 3.
Please, your lordship. Why is it page 13, lordship? Petitioner's name is not in the FIR, lordship.
Hmm?
Petitioner's name is not in the FIR, and lordship, only the petitioner's name is same as Sohidul Islam, an arrested accused person relating to the above mentioned overpay case, lordship.
My lord, no, CD required, my lord.
Lordship, some persons were arrested in connection with this case. Lordship, they were released on bail by this honorable court, lordship.
These are, my lord, arrested person granted, my lord, this is anticipatory bail. And, my lord, if FIR, no, my lord, there is no name in the FIR, where is the apprehension, my lord? So something is there, we have to verify the CD, my lord.
Okay, heard so-and-so, the learned counsel is preparing for the accused applicant, also heard QQ Parasar, and APP for the state. It is an application on the so-and-so. The case relates to filing of an FIR dated 29/11/2025 with the allegation that some miscreants entered the house of the informant and after spraying certain substance in the face of the 3 family members, they broke the almirah and left stealing golden ornaments and cash amount of rupees 24,000. Full stop. Call for the CD. Let the matter be fixed on 6th of March. 6th of March.
Item 4.
May I please, Lord? Lord, under section POCSO 6, my lord. CD
Heard
will
Mr. Farali, the learned counsel appeal the accused applicant, also heard Mr. KK Parasar and APP. Read an application under so-and-so. The case relates to am I right like this? An FIR was lodged on 5/9/2025 alleging that the accused person is after inducing by inducing the accused applicant number one. How many people are there? One people, no?
One month. Others.
He's the main,
Lordship,
person.
others already granted bail, my lord.
Okay, the accused applicant, after inducing the informant's sister, has committed rape on her. Full stop. Let notice be issued on respondent number two to the registry in terms of the prevailing notification issued by the Gauhati High Court. Then notice to respondent number one is dispensed with as he enters appearance. Call for the CD. Let the matter be fixed on 12th of March.
Okay.
5,
May I please your lordships, with this Genesis application lordships, the allegation as per the FIR is that lordships, 4 numbers of vehicular seized by the Demo police station lordships regarding transportation of cattle lordships. And the present petitioners are the owner of the vehicle lordships. And subsequently they have filed a Jimma petition before the learned court below. The court below has granted Jimma of the said vehicle. I have annexed the order at page number 34 lordships.
Yeah, I mean, accused are
No, the
owners of the vehicles.
vehicle lordships. They are commercial vehicle, they have, the vehicle taken hired by the cattle owner lordships. The commercial vehicle lordships and the vehicle has been already granted Jimma by the learned court below.
And is there any permit from, as per the cattle prevention?
Lordships, the Cattle Preservation Act is not attacked in this case, lordship.
Why?
Because the Assam Cattle Preservation Act amended, lordship. As per section 7, subsection 6, clause 2, lordship.
Hmm.
No permission is required for transportation of cattle, lordship. Lordship, may kindly see.
Assam,
Lordship, kindly section 7, subsection 6, clause 2, lordship.
Section 6 is permit for transportation of cattle.
Lordship, lordship, your
Oh,
lordship, may
this
kindly
has
see.
been amended?
Then, lordship, this came in 2021 and amended in 2022, lordship. Lordship, may now kindly see section 7, subsection 6, clause 2.
No, 6, what about 6? 6 has been amended.
No, lordship, section 7 has been amended, lordship. Lordship, relevant provision, section 7, lordship.
7 is what? No, section 6 is permit for transportation of cattle. Do you have the permission?
No, lordship, your lordship, may kindly see section 7.
Section 7 is
Section
what?
7, subsection 6, clause 2, lordship. No permission shall be required for carrying cattle to and from a registered animal market for the purpose of sale and purchase of such cattle within the state. Lordship, if the cattle is purchased from the registered market, lordship, no person is required. Lordship, I have annexed also the cattle purchase receipt, lordship. The cattle has been purchased from the registered market, lordship. Page number, lordships.
No, 7, when it is amended, I don't have the amended version. You give me that amended version.
Lordship.
Section 7 says registration of an agency or firm.
No, lordship, section 7, your lordship, may kindly see section 7, subsection 6, clause 2, lordship.
One second. So,
Section 7, subsection 6, clause 1 and 2, lordships, the exception, lordship. If the cattle is purchased from the registered market, lordships, no permission is required for transport cattle, lordship. Within the state, lordship. Earlier, lordship, that permission is required to transport cattle from one district to another, lordship. Now the section has been amended, lordship. If the cattle is purchased from the registered market, lordship, no permission is required to transport cattle from one district to another, lordship. But there is an exception, lordship. Exception is that, lordship. The permission is required to transport cattle to those district, lordship, where international border is sharing, lordship. I have also annexed the cattle purchase receipt, lordship, page number 15 onwards, lordship. One Abdul Hussain, lordship, is the owner of the cattle, lordship, and Riazuddin, two. I have annexed the cattle purchase receipt at page number 14 to lordships, 33, lordships. And this market has been registered by the
one second. Okay, this one I have, I got it now. Let's give it back to him.
Only section 11A and D will apply, Lordship. It is a bailable offense, Lordship.
See, two says, exceptions 262 says, no permission shall be required for carrying cattle to and from registered animal market
Lordship,
for the purpose of sale and purchase.
Lordship.
I mean, to and fro the registered market.
Yes, Lordship. I have purchased from the registered market.
Then whether you are taking to a registered market,
Yes, Lordship.
from where you are saying so?
Yes, Lordship, page number 15, your Lordship, may kindly see. It's a registered market, Lordship. There's a
No,
market is there.
registered market you have bought, but
Okay.
where you are taking?
I'm carrying, taking to the.
Which market?
No, Lordship.
No, which market? Where is the material?
No, I have not mentioned. but
Then how come this exception will come here?
No, to and from, Lordship.
To and from.
Yes, to and from, Lordship.
Yes, then
I can purchase from Lordship's, registered market, Lordship. I can carry to the registered market, Lordship. It's not mentioned that, Lordship, that I have to, purchase from registered market, I have to carry to the registered market, Lordship. This is not a provision, Lordship. The provision is that, Lordship, I can carry to the registered market, I can purchase from the registered market. That is the meaning, Lordship. It is not, that, Lordship, that I have to purchase from the registered market, or again I have to take into the registered market. It's not a provision, Lordship.
the rule has been also amended.
Yeah, rule has been, no, I am not going to the rule, Lordship. Rule
But rule is still there.
Rule is still there, Lordship. Here, Lordship, the transportation of animal rule will applicable as per section 7, subsection 5, Lordship. And if the transportation rule break by the petitioner, Lordship, then the section 11(1)(a) and D of the Prevention of Cruelty to Animals Act will be applicable, Lordship. It is a bailable offense of 50 rupees fine, Lordship. And section 29 of the state act, Lordship. So for section 303, close to BNSS, Lordship, that section is not applicable, Lordship, because it's not a stolen cattle, Lordship, it's a purchase from the registered market. Moreover, Lordship, the last 2 months, the vehicle is lying idle in the police station, Lordship. The vehicle has already given Jimma by the landed court below, Lordship.
Yes, Mr. Bushra.
My lord. My lord, at this stage, my lord, CD may be called for a short date, my lord, because my lord, here, my lord, in the FIR, my lord, one, my lord, another line is there, my lord,
Okay, we'll call for the CD.
my lord.
Heard Mr. T. Chakriya, the learned counsel appearing for the accused applicant, also heard so and so. That, right, this is an application under so and so. An FIR was lost. Lost on 12/12/2025 with the allegation that the accused applicants were transporting cattle without any documentation. Call for the CD, let the matter be fixed on.
6, Lordship, the similar matter was fixed on that day, Lordship. 6/3, Lordship.
6/3.
Along with AB number 371/2026, Lordship.
Fix the matter along with AB number AB number, just give the AB number.
AB number also 371, 2026.
Mr. Boisho, you see that these provisions, you should see that because this matters keeps on coming.
Yes, yes, my lord.
No, otherwise,
go through it.
this act has been amended also in 2022 also. Otherwise, also.
No, I mean, though, these are all illegal things. I mean, whatever you say, I mean,
Okay.
court is also aware what is happening.
Okay. Market is running by the government logic.
No, we understand.
They are taking revenue from the state.
We understand, Mr. Chetia.
Lordship.
We understand.
Obliged, Lordship.
Please, your lordship.
Yes.
My lord, this applicant who is aged about 70 years, my lord, has preferred this 3 years bail application, my lord, on an FIR lodged by, would have been daughter-in-law, my lord. And the FIR, on the page. FIR is at page 17, my lord,
Page
17, my lord.
17.
The main content. Because 2 persons has been named in the FIR, the son and the father, my lord.
Okay.
With due respect, I beg to state that in May 21, I made accused number 1, Sri Chandran Borthakur. He is the son, not before your lordship. Thereafter, he proposed marriage to me, which I believed him, and his proposal accepted in good faith. From 9/7/23, we were in relationship, and from 1st October 23, we started living together in a live-in relationship like husband and wife. During this period, accused number 1 repeatedly assured me that he would marry me soon after settling financially. Relying upon his continuous promise of marriage, I consented to physical relation with him. Subsequently, I conceived. When I informed accused number 1 of my condition and requested him to solemnize our marriage, I also conveyed to him that I wish to carry the pregnancy to term and give birth to the child. I also approached his father. Accused number 2, Sri Prashant Borthakur, requesting them to arrange the marriage. This is me, my lord, the applicant. The earliest. However, instead of marrying me, accused number 1 forcibly compelled me to terminate my pregnancy. He physically assaulted me and threatened me with dire consequences. I was forced to go to Pratiksha Hospital with accused number 1, where my pregnancy was terminated against my free will and my signature was obtained forcibly. The accused number 1 also put his signature in the consent form. Accused number 1 again assured that he would marry me, stating that his family would not accept his child before marriage. Thereafter, on 7/9, accused number 1 suddenly abandoned me, and about 20 days, due to which I was compelled to lodge a missing report. Later on 6/11/25, I went to his residence. She came to my place, my lord. Here is the twist. And to ascertain the truth, there I was physically harassed and humiliated. In the presence of his family member, accused number 1 clearly denied any promise of marriage and stated that he never intended to marry me. His father, accused number 2, attempted to assault me and abuse me by using...
Yes, Mr. Boisho.
My lord.
My lord,
Father, my lord.
Father is
Or
room
Mr.
based.
J. Kamar, the learned counsel, the learned senior counsel, assisted by so-and-so for the accused applicant. Also heard Mr. K. Boisho, the learned APT for the state. This is an application under so-and-so. An FIR was lodged on 11/2/2026 by the informant, alleging that that one what is the yes, one Chandan Borthakur. Chandan Borthakur induced
Chandran Borthakur is the son.
Chandan Borthakur induced her to get into a relationship with the promise of marriage, and thereafter she started living with him, and during during her stay, she got pregnant. Semicolon that the accused applicant that therefore say Chandan Borthakur later on refused to marry him and forced her to terminate her pregnancy. It was also alleged that the father of the accused, father of the aforesaid Chandan Borthakur, the accused applicant in the instant case has also abetted the aforesaid acts. On filing of the FIR, the Hatigam Police Station case number 0031/2026 under the aforementioned section was registered against the accused persons, including the accused applicant. Full stop. Mr. J. Kamar, the learned senior counsel, submits that submits that there is no abatement from the side of the accused applicant, and accused applicant is a 17 years old person, and he doesn't have any knowledge about any false promise of marriage or abortion of pregnancy, abortion of pregnancy of the informant, full stop. He submits that he is a respectable citizen and fully cooperate with the investigation in the instant matter, full stop. Mr. K.K. Baisya, the learned APP, on the other hand, submits that without perusing the case diary, the bail of the accused applicant should not be considered at this stage, full stop. On consideration of the materials brought before this court, and after hearing the submission of the counsel appearing for the respective parties, this court is of the considered opinion that at this stage, the accused applicant merits the protection of pre-arrest bail. Accordingly, it is directed that in the event of the arrest of the accused applicant by the investigating authority in connection with Hattigaon Police Station case number 0031/2026, he shall be released on bail on furnishing a bail bond of rupees 30,000 with a surety of like nature to the satisfaction of the arresting authority, with the condition that the accused applicant shall appear before the investigating authority within 10 days of passing of this order, and he shall fully cooperate with the investigation in the instant case. In view of the aforesaid direction, the instant AB application is disposed of as allowed.
For motion item number 7.
Item number 7, one is there. Okay. None appeared for none appeared for the petitioner when the matter was called for. Let the matter be listed in the second week of March.
8.
Please, your lordship, kindly pass over for time being.
Pass over time being.
Bail hearing item number 13.
Item number 30, my lord, scan copy was called for, my lord. And in the meantime, my lord, service report also received, my lord. So some amicus may be appointed, my lord.
But none is, nobody is representing. Listed in the, none appeared for the accused applicant when the matter was called for. Let the matter be listed on 6th
6 March.
6th of March.
My lord.
These are pretty new.
Number 14.
Lower is ना 6 to 9 हो गया उसको 6 मत करो. The last one make it
Change the date.
change that and make it on
Item number 15, my lord, on the last occasion, amicus appointed, my lord.
make it on
14, my
11
lord.
11 till 11.
14 charges submitted, my lord.
Lordship, I was on interim bail, my lord. After 77 days remaining in custody, my lord, I was granted interim bail by this honorable court, my lord. So, my lord, that may be made absolute. I will appear, my lord. Order dated 25/11, my lord. I was in custody for 77 days earlier, my lord.
Order dated
25/11/2020.
heard Mr.
A. Choudhury.
A. Chaudhary, the learned counsel appearing for the accused applicant. Also heard Mr. R.G. Bura, learned APP for the state. Then you write this is an application. The learned APP submits that in the instant case charge sheet has already been filed by
Being charge sheet number 77/2025, dated 30/11/2025.
let me see,
30/11.
30/11. In view of the, it is seen that by order of the 25/11/2025, the accused applicant was granted interim bail in the instant case. Full stop. In view of the aforesaid, the learned counsel appearing for the accused applicant submits that he should be given protection till the time he appears before the learned trial court. Full stop. Next paragraph. In view of the aforesaid facts, it is the interim order so passed on 25/11/2025 is extended till the appearance of the accused applicant before the trial court. Before the trial court in connection with Bagbor PS case number 60/2025. Accordingly, the instant bail application is disposed of.
I love.
Number 15.
My lord, I beg apology. Item number 10, my lord.
Don't come like this. When a matter is called. You come later on, when the matter is over. Don't come like this in between. No. When the matter was called for, you were not there, order has been passed.
15.
And suddenly don't jump in to mention the matter.
15, my lord, amicus appointed on the last occasion, my lord. And scan copy received, my lord.
Hmm?
Received the copy. I've been appointed amicus in this case.
You have received a copy?
Not yet, Your
You
Honor.
haven't?
I'll provide, my lord. Can be tomorrow, my lord.
Okay, you give her a copy.
Today
and
itself,
we'll-
I'll give, my lord. Can be tomorrow, my lord.
No, tomorrow not possible.
Then Friday, my lord, kindly.
Friday also not possible. First week of March sometime.
My lord.
Second,
Actually, I have
second,
gone through the PCR.
second, how many matters are there? Second, how many?
Can be on Friday, my lord.
One second. Missing, I know it has 25 already.
Applications were direct.
My lord, I pray for Friday, my lord.
25. Saturday. Nine to boarding, no?
Can be Friday, man. Because I have gone through the
The
TCR.
board is fixed actually. We are just trying to locate a date where we can put it. Already so many matters are fixed. Huh?
I have gone through the TCR, my lord, in the arrest memo, my lord, that witness signature is not there.
You know, that is fine, but I mean, that has to be examined. I
Fine,
mean,
that's fine.
so many matters have been fixed, already full.
My lord.
So, I mean, it won't be possible to take up all the matter.
Then second, my lord.
Second is full.
Then fifth,
Now
my
has heard Mr. D. Bora, the learned counsel appearing for the accused applicant, also heard Mr. R.J. Borua, learned APP, and MS
S. Dawar.
S.
Newar.
S. Neva, the learned amicus, learned amicus K, representing the respondent number 2. The learned amicus submits that she is yet to receive the copy of the bail application. Full stop. In view of the aforesaid, the matter will be listed on.
Can be fifth, my lord. After holy.
Ninth.
My lord, otherwise can it be on sixth, my lord, sixth, my lord.
Six not possible, I'm saying, na? Board is full.
Really good.
My lord.
Board is full. Already 35 matters fixed and other matters are also coming.
9th of March, my lord.
9th of March.
My lord.
Obligation.
Number 16.
16, my lord, charge sheet submitted, my lord.
In this regular bail application, I was granted interim bail, my lord, on 10/12/2025.
Dated?
10/12/2025. This happened, my lord, after that Danny Bombla, somebody.
You write, maybe that same order will go. But the search sheet submitted when? Heard Mr. S. Nawaz, the learned counsel appearing for the accused applicant. Also heard Mr. R.J. Borua, learned APP for the state. This is an application you write. Then you write, the learned APP submits the charge sheet in the instant case has already been filed, already been
Being-
submitted by
I searching number, my lord, 3/2026, dated 25/1/2026.
The learned counsel, if the accused applicant submits that the accused applicant has already been granted interim protection by order dated 10/12/2025, 25, and he should be allowed to appear before the trial court. Until till that time, he should be protected. Taking into account the aforesaid submission, this court submission, it is directed that the interim protection so granted on 10/12/2025 shall be extended till the time the accused applicant appears before the trial court in connection with Mongolday PS case number 208/2025. In the aforesaid term, the instant bail application is disposed of.
17.
17, my lord, as their service report completed, my lord.
Hmm?
Service completed, my lord, on the last occasion, amicus was appointed.
Hmm.
My lord, today, my lord, 10 copy received, my lord.
Scan copy received, yes. You go to the other side. You want to argue the matter? Yes.
Lordship, the real fact of the case is the victim and the petitioner are in normal, regular love relationship as a normal young couple.
Hmm?
As a normal young couple, they are in love relationship, Your Lordship.
Where is the FIR?
FIR is 9 years.
Page
9 years.
9.
to 14.
Yes.
And accordingly, Your Lordship settled for a better that they elope. And there was no question of abduction or something whatsoever, Your Lordship. There is a pure love relationship. And they have eloped from their home and they lived for some days until the parents of the victim handed over them to the police, Your Lordship. And so the FIR was lost, Your Lordship. And it is pertinent to mention, Your Lordship, during the FIR, she was just.
You
8
read the
days-
FIR first, read the FIR first. Or let me read it.
Yes, sir.
Yes.
Lordship, it is pertinent to mention that during filing of the FIR, Your Lordship, she was 8 days left to attain her majority, that is 18 years. No, Your Lordship. And
You were arrested on 29,
arrested on 3/9, Your Lordship.
39.
3/9/2020. 5 months, 22 days.
So how many days now?
5 months, 22 days, Your Lordship.
Huh?
5 months, 22 days.
5 months, 22 days. TCR.
160 was taken up.
So on the date of arrest, what was her age?
Date of arrest, your lordship.
Or on commission of, I mean, with the allegation of, the date of allegation of commission of.
Lordship, may kindly come to page number 22 of the bail application.
Hmm. She's around 18 years, I think.
17 years, 4 months, my lord.
Hmm?
That was at the time of,
No, it will be more than that.
at the time
At the time of
lodging
incident.
the FIR, she was 8 days left to attend her majority. At the time of lodging the FIR, your lordship.
From the search sheet, my lord, it is clear, my lord, that she was at the time of incident 7 years, 4 months. 17 years, 4 months.
Why not?
She was old enough, your lordship, to give her free consent, your lordship.
Yes.
The search sheet, my lord, she was minor at the time of incident.
Hmm?
Let the victim examine.
My lord, it's a pure case of like normal love story, your lordship.
No, it's
They
not
have
a
gone
pure case
extent-
of normal love story.
Extent, there is
It's
a
not
lack
a
of
pure
awareness,
case
your
of
lordship.
normal love story.
It's a lack of awareness, your lordship. I
Your
would
own
put it.
cousin sister, right? Your own cousin sister. Yeah, you have forced her to go with him.
We will in the trial court, your lordship. As of now, all the formalities have been done, statements have been recorded, your lordship. There is no chance of.
What is the stage now? Have you seen, what is the stage now? How many witnesses have been examined?
Not examined, my lord.
No, I think they have examined.
Any condition may put, your lordship.
See, there is no story of love here. There was no love story. So what you are trying to portray is not correct. This is apparent from this thing. Because I mean, there was some issue regarding selling of gold ornaments that she owns, and you have taken those forcefully.
Was before the elope, your lordship, but after.
But that is why you have coerced her. You'll have to go with her.
Peacefully for some days, but there's a lack of awareness, your lordship. Any condition may be put, your lordship.
Yes, you have anything to say?
Yes, my lord. My lord, even the medical report shows that the hymen was not intact, my lord.
Hmm.
Yes, ma'am. At this stage, if bail is granted to the accused, there's chances of accused influencing the witnesses as well as the victim, my lord.
There's no such chance, your lordship, because
Heard Mr.
A.B. Datta, your lordship.
Hmm?
A.B. Datta.
A.B. Datta, the learned counsel appearing for the accused applicant, also heard Mr. R.J. Borwa, learned AVP for the state, as well as MS
Sneha Kalita, my lord.
Neha Kalita, the learned amicus curiae, representing respondent number 2. This is an application under so and so. An FIR was lodged on 292025 by the parents, by the mother of the mother of the victim girl, alleging that her daughter is at about 17 years. 17 years was induced by the accused applicant and took her away with the intention of marrying her. That it was further alleged that in spite of active search, she could not be located. However, later on receipt of certain information, her daughter was recovered from a place named Bhogdol, Jurhat. After their recovery, the accused applicant as well as the informant's daughter was handed over to police, and later on the daughter was brought back home. On receipt of the FIR, the police registered Merapani PS case number 74/2025 under section 87 of BNS 2023. Full stop. The accused applicant was arrested on 3/9/2025. Next, this one, 25, and for the last 5 months and 20 days, he is behind the bars. After the investigation, police files charge sheet in the incident case by charge sheet number 60/2025, and the case is pending before the special judge POCSO Gulagat, wherein two of the PWs have already been examined, including the victim. Full stop. The learned counsel appearing for the accused applicant submits that since there are 11 charge sheeted, as 11 witnesses PWs were mentioned, were listed in the charge sheet, the trial will take considerable time, and taking into account the length of detention of the accused applicant as well as the age of the victim girl, the accused applicant should be allowed to go on bail at this stage. Full stop. On the other hand, Mr. R.J. Borua, the learned APP for the state, opposes the bail application, saying that there are materials, there are prima facie materials against the accused applicant of his involvement of forcibly taking the minor girl of the informant along with him, full stop. Therefore, he opposes the bail application. MS Kalita, the amicus curiae submits that as per the medical report, the hymen of the victim girl is found to be broken. And since she is a minor girl, there is a prima facie material against, prima facie incriminating materials against the accused applicant. Therefore, she opposes the bail application. Taking into the whole facts of the case, as well as on perusal of the trial court record, which has been produced before this court is of the considered opinion that at this stage, the bail to the accused applicant should not be granted. Accordingly, the instant bail application is rejected.
Your lordship, kindly in that case, list it after 2 weeks. I want to like.
It has been rejected already. It has been rejected.
Kindly that may be granted, your lordship, at this.
It has been rejected, Mr. Counsel. I have seen the materials. I have seen the materials. After going through the materials, I am not convinced that bail should be granted at this point of time. That's why I have rejected. If there would not have been some materials, then I would not have rejected. Correct? I have gone through the TCA. The depositions I have gone through. There are a lot of materials against him. Let the trial court decide.
18.
18 to 31 and 18 to 20.
May I please, this is a POSCO case, my lord. My lord, FIR is at page 12, this is the Bhanda clause, and the
Before the trial court on receipt of summons.
On receipt.
Yeah, on receipt of summons. Full stop. Yeah, in view of the opposite direction, the instant bail application is disposed of.
Highly obliged.
20.
It is lost, sir. It's a charge sheeted case, my lord. It's a charge sheeted case, my lord, where, my lord, 16 number of witnesses are cited, my lord. Out of 16, my lord, 5 witnesses have been, my lord, examined, my lord.
7.
Sorry, 7, my lord.
Yes.
My lord, the informant and the victims were examined, my lord. Lord, I will draw your lordship attention to page 36, my lord.
Yes. Yes, 36
36, my lord.
is deposition of PW3.
Yes, my lord. My lord, from below, my lord, 1, 2, 3.
3 is the victim.
Yes, my lord. From below, my lord, 8th line, my lord. My parental aunt, lordship had got it.
Mm.
My parental aunt, Morgina, tutored me how to give evidence in the court. Here, my lord, the informant and the victim had already been examined, my lord. And there is no chance of, my lord, tampering the evidence, my lord. Rest I leave it to your lordship, my.
When, I mean, they're behind the bars for how many?
Behind the bar from, my lord, 220525.
22?
0525. As because, my lord, the informant and the victim already examined. I will face the trial.
There are two victims, Mr. Datta.
Yes, but two victims, my lord.
Difficult at this stage.
I leave it to lordship.
Heard Mr. N.J. Datta, the learned counsel appearing for the accused applicant. Applicant also heard Mr. R.G. Borua, the learned APP for the state. State, this is an application under so and so. An FIR was lodged on 22/12/2025 by one Morzina Begum. The informant alleging the informant alleging that Mr. Doctor, who has translated this?
My lord, I have seen, my lord, that's why I'm not.
I mean, some statement, I mean, which has been made in paragraph 2, you just have a look.
Yes, my lord. My lord, I think
Who has
the-
done it? You have done it? Who has done it?
My lord, one of my junior, my lord, I have seen, my lord.
See, they say, there is nothing in the affair
I-
about any kind of love angle,
No, no, no.
love affair or
That's-
whatever.
That's,
This is, I mean,
better I withdraw, my lord.
yeah, you better withdraw it.
Withdraw, but I
You
withdraw.
withdraw it. I mean, this
Yes,
is
yes, ma'am.
purely misrepresentation kind of thing.
I withdraw, my lord.
Better you withdraw it. Mr. N.J. Datta, the learned.
That's why, my lord, I'm saying, I leave it to lordship.
Yes, I mean, otherwise also materials are not
Yes.
there. I mean, and there is, I mean, fully different kind of story
Yes.
has been put in. And translation is totally, I mean, vernacular is totally different. Heard Mr. N.J. Datta, learned counsel for the accused applicant. Also heard Mr. R.J. Borwa, learned AP for the state. You are appearing for some? BD, go. BK, for the informant.
Yes.
For the informant, Mr. Datta submits that he wishes to withdraw this present bail application where is allowed. The matter is dismissed as withdrawn.
21.
My lord, regular bail application, my lord. The petitioner was released on interim bail, my lord, on order dated 19/12/25, my lord. Thereafter, notice was issued and city was called for, my lord. Our city is also available, my lord. The FIR is at page 11. May I read the FIR, my lord?
Charge sheet filed in this matter.
No, but the investigation is pending, my lord.
Huh?
Because the main accused person, my lord, he is yet to arrest, my lord.
I am accused number 2, my lord. There is no.
He is the
Mr.
brother of the main accused person, my lord.
He is the brother.
Yes.
Brother of the
Both
main-
of you, allegations are both of them. Where is the FIR?
Not my,
Page,
that,
page
my lord,
11, my lord.
then if POCSO will not come, my lord. POCSO may not come. my
The
lord.
POCSO may not come, but
My lord, in the FIR, my lord. no
other
further
allegations are
accused
there.
present. My lord, he is simply named in the list of the accused person, my lord. Nothing is accused, labeled technician.
Your name is
Kausar Ahmed, my lord, accused number 2.
Kaswar Ahmed. You are accused number 2.
2, my lord. The main accused is my younger brother. Moreover, my lord, The incident took place on 4/4/2025, my lord, and the FIR was lodged on 9/9/2025, after 5 months of delay.
Any allegations against him? Against him, there is nothing.
So in her, 183 statement, my lord,
Hmm.
is written in Bangla, my lord. I am not good in, my lord, understanding, my lord, but there is allegation, my lord, the victim was taken to Mizoram, my lord. She was kept there for 2 months, my lord, and she was physically tortured, my lord.
Physically tortures them,
Sexually
assaulted by accused number one.
One, my lord.
And there are some allegations against 3, 4 also.
Yes, 3 and 4.
3 and 4 also, but against 2 there is nothing. I think.
Nothing.
And he is already in interim bail. Is there anything, Mr. Borua?
My lord, that, my lord, only this person, lordship, may kindly listen, my lord. I'm not been able to understand properly. my
I'll understand. I read Bengali.
lord. Yes, I can read, but my lord, regarding understanding, my lord.
We read lot of Bengali novels in our school days.
That language is a little bit Siletia, my lord.
Sarat Chandra, Rabi Thakur, lots. Where?
The red mark, my lord. His name is Kausar Ahmed. Regarding some substance and contraband, my lord, that there is some allegation. He was given.
Maybe some ganja or something like that. I mean, because there are things like cooking. I mean, cooking drugs cannot be cooked. Maybe like lot of people put those ganja and all in, I mean, during the cooking thing stuffs.
my lord.
Maybe that I don't know, but I mean, nothing much is there. Heard Mr. S.S. Ahmed, the learned counsel, appearing for the accused applicant, also heard Mr. R.J. Burwa, learned APP for the state, as well as
T. Pathak, amicus
MST Pathak, the learned amicus curiae, appearing for respondent number 2. And you write, an FIR was lodged. This is an application, you write, huh? This is an application. FIR was lodged on
9/2025, my lord.
when the FIR was lodged. There is no date in your translation.
9/9/2020.
Hmm?
9/9/2025, my lord.
9/9/2025 by one Hasna Begum, the mother of the victim girl, alleging that one Sujan Ahmed, the accused number 1, along with 3 other persons named in the FIR, helped the accused number one, namely the accused number 1, to kidnap her daughter, and thereafter kidnapped her daughter. It was alleged, full stop 0, then it was alleged that thereafter she was taken to Mizoram with the help of accused number 3, namely Hina Begum, and accused number 4, namely Sahabuddin, to Mizoram forcefully. And there the accused number 1 raped the minor daughter of the accused, a minor daughter of the informant. Full stop. On receipt of the FIR, police registered Patharkandi PS case number 209/2025 under the aforementioned sections. Full stop. The learned counsel appearing for the accused applicant submits that accused applicant is the brother of the brother of the main accused, that is accused of one number one named in the FIR, and he does not have any role in kidnapping and raping of the victim girl. If he submits that only because he is the brother of the accused applicant, he has been named in the FIR, full stop. He further submits that by an order dated 19/12/2025, the accused applicant has already been granted interim bail. And in terms of the interim bail, he has already appeared before the investigating authority.
Regular bail.
I mean, when the bail was given, you were, it's
My lord,
okay.
there was no such direction for appearance, my lord. But I
Appear
was
where?
behind bars for 49 days, my lord.
Hmm.
Thereafter, I was, my lord, 19/12/25.
No, you appeared before the investigating authority. Charge sheet was filed at the time.
No, my lord. It's satisfactory, not yet filed, my lord.
So what's wrong in the dictation? You said something, I mean, while I was
I was
dictating.
saying, my lord, that I have already released from the bars, my lord.
That's what I'm saying. I'm saying something else over.
No, my lord. I have apologize.
In terms of the aforesaid order, you appeared before the IO, isn't it? After getting the bail,
Yes, ma'am.
you appeared.
Yes, ma'am.
That's what I'm writing. He appeared before the investigating officer. He, in terms, क्या लिखा? He has already appeared before the investigating officer. Full stop. The charge sheet in the instant matter has been filed on,
Not yet
No,
filed, my lord.
investigation pending.
not,
The other accused person are yet to be arrested.
okay. And he's appeared before the investigating officer and fully cooperating with the investigation. Therefore, fully cooperating with the investigation. Therefore, he submits that his interim bail should be confirmed at this stage. Full stop. On the other hand, the learned APP submits that since the main accused in the instant case is yet to be arrested, and there are prima facie materials against the involvement of the accused applicant also, at this stage bail should not be granted. Bail should not be confirmed. Interim bail should not be confirmed. Confirmed at this stage. Full stop. The learned amicus curiae has also supported the contention raised by the APP. Full stop. Taking into account the whole facts of the matter and on perusal of the case diary, this court is of the considered opinion that the interim orders were passed earlier by dated 19/12/2025 is required to be confirmed. Accordingly, the interim order 19/12/2025 is confirmed with the same terms and conditions as mentioned in the aforesaid order. In view of the aforesaid direction, the instant bail application is disposed of.
22.
We need to pay the receipt only.
Did they receive? Okay.
One of petitioner was arrested on 20/12/2025. He himself cooperated with the investigating authority, madam, because he is not named in the FIR, madam. Only as his marriage was fixed with the deceased. Police called him, accordingly cooperated with the investigating authority, madam. FIR is a prestigious law.
When was he, when was he arrested? This person?
He was arrested on 20/12/2025, madam.
20/12/2025.
67 days. He was called by the police and because marriage of the petitioner was fixed with the victim lordship.
We received the case diary, my lord. Document kindly pay the inquest report, my lord.
Hmm?
The inquest report, but the postmortem report is yet to receive, my lord.
Hmm.
Inquest report and the statement of the witnesses as well as the statement of the accused person, my lord. Because there are allegation is that, my lord, there is a love affair between, my lord, accused and the informant, my lord. Sorry, accused and the victim, my lord.
At this stage, it will be difficult.
My lord, postmortem report may be called for also.
No, postmortem report will not help, madam.
Let's see lordship.
Madam, I mean, at this stage, it will be difficult. There are some materials are there against him. I mean, and investigation is still on. So
That is your lordship.
It
He
will
said
be-
that is your lordship. If possible, postmortem to
the
complete.
postmortem will not help much.
Request for the prosecution lordship. But because lordship, there
Postmortem
was,
will not help.
at that,
See, I mean, there is no, I mean, there are materials and like, you could not give any uh, convincing reply about your whereabouts. And
Madam-
strong cases against you.
well, at least, yes, lordship, will kindly call for this postmortem because he is inside the jail, madam. And he himself appeared before the IO lordship when called for lordship.
No, no, I mean, postmortem utility report, but what's the point of pending it for postmortem report? Will it help?
It is pending, my lord, so it is there to collect the postmortem.
Okay, we'll give you one date. I mean, we'll keep it pending. Heard MS Nagis, the learned counsel appearing for the accused applicant, also heard Ajay Burwal and APP for the state. It is submitted by the APP that postmortem report in the instant case is yet to be received. Is received. Wait for the postmortem report. Let the matter be listed on 18 March. 18 March.
1/8, my lord.
1/8.
My lord.
Obligation.
We'll just come back in 5 minutes.
এটা পড়লো গুলো।
For a retrieve bail application, your lordship, and offense registered under NDPS Act, your lordship. FIR at page 9, annexure 1. The allegations in the FIR is that 29 kgs of cannabis that was recovered from his house. And the allegation is that he was storing this cannabis in his house for selling purpose. So FIR was lodged on 11/8/25, and on 11/8/25 itself, he was arrested. And he was forwarded before the Chief Judicial Magistrate on 12/8/2025, your lordship. And since then, he has been there in the case. Lordship, annexure 37, 30, it is 39. Siscoli, I have annexed a medical document. At the time of arrest, your lordship, he was suffering from chronic cyst in his right kidney. And he was supposed to be admitted in the Lokhimpur Medical College Hospital to undergo surgery, your lordship. But since then, he has been there in the jail. Now the infection is there and that has been spread, your lordship. His health condition has become very fatal, your lordship. He needs some specialized medical treatment.
How much was the quantity?
Quantity is 29.815 kg.
20?
29.815 kg. 29 kg, 815 grams. The problem he's facing there, your lordship, he needs some specialized treatment because already infections that has been spread because of that kidney cyst, which was supposed to be removed during that time when he was arrested actually. All the arrangement was done to get admitted in the Lakhimpur Medical College Hospital, but in the meantime, he was arrested. And because of that, he has been carrying that cyst there. That has not been removed, could not be removed because of being in the jail. And now the infection has taken place. So health condition has become so fatal, your lordship, so specialized medical treatment is required.
But the reports are reports are from,
From 24, actually, 24. he
so
was
you got,
consulting-
you got more than, I mean, more than a year.
But his condition was not so well because in the Lakhimpur Medical Hospital, he was the cyst was found. It was diagnosed. So
It was
he
diagnosed, it was diagnosed 1 year and 4 months back.
still there, but he was supposed to be a medical college.
So like you got 1 year and 4 months.
But yes, now the infection has taken place, your loss.
How do I get to know about this?
No, they visited the family members, visited the jail to see him. His condition is not also very good in a well health. And he was brought to the trial court also. There also his son made him. He revealed his pain and problems, everything here also. So my humble prayer that Article 21 may be looked into by your lordship, which may override the stringent restriction of Section 37. At that time, it was 9 mm. Now, obviously, that has been increased. The size and infections also.
But nothing is there in on record about his illness.
So these are medical documents only. I could collect this.
No, there was no mention in the orders also that he was not keeping well. He didn't inform to the trial court.
In a trial court order.
He could do this. To 24 to 24 to
In the trial court, they moved the bail application, but whether they have taken this as ground or not, I think it is not reflected. So
No, he has been regularly attending the trial court.
yes, yes, jail production
So,
is there.
correct. So, I mean, there is no mention about his illness, nowhere. Stating that he is not keeping well. There is nothing.
But he expressed to his family members.
But expressing to his family
Literate
members.
person
how-
also probably. he could
Yes,
not
Mr. Borwa.
give
My
it.
lord, I have gone to the scan copy of the record, my lord. The case diary has not come, my lord. And I want the scan copy of the record, my lord. Only, my lord, the trial court record has come. My lord. CD will be required, my lord. And secondly, my lord, regarding his, my lord, ailment, my lord, also may call for a report from the jail authority, my lord.
There may be call also, your lordship.
Okay, we'll
Present status of that.
heard Mr. So-and-so, and so-and-so. It is an application under so-and-so. It is submitted by the learned counsel appearing for the accused applicant that The accused applicant is suffering from severe kidney disease and he requires immediate medical attention. Full stop. It is seen that CD case diary in the instant case is yet to be received, though the scan copy of the trial court record relating to a special NDPS case number 55/2025 is received. Full stop. Await for the case diary. In the meantime, the jail authorities, which jail?
Lakhimpur Jail.
Lakhimpur Jail, Your Worship.
Jail authorities of Lakhimpur to submit a report on the health status of the accused applicant before this court. Let the matter be listed on 19th of March.
19.
24.
No, this is after some time, my lord. My learned friend has gone through, my lord, after some time.
Then, 2 PM Lordship.
After some time, 2 PM, some other cases.
26.
Same time, Lordship.
No, Lordship can dispose of this main matter, but I'll just show one, I know to the investigating officer. It will discuss by the way. The settlement of the- And he is also appearing for the informant, man. Seven to seven. Common. 27 to 7.
What was the allegation?
Well, actually,
Extortion, man.
My lord, if your lordship kindly see the order passed by this court, my lord, on 4/2/2026, my lord.
Okay, let him go. I mean, here
He's
the
also appearing for the informant, man.
money has been paid also,
Yes, ma'am.
returned. Heard Mr. Anjay Datta, learned counsel appearing for the accused applicant, also heard Mr. R.J. Burwa, learned APP for the state, as well as Mr.
AM Khan, Your Lordship.
A.M. Khan for the informant. There is an application, you write, huh? The gist of the allegation in the FIR dated 18/1/2026 is that some persons impersonating as income tax officials forcefully extorted money from whom?
Informant, my lord, page 20.
Money from the petitioner, money from the informant, threatening them about.
Right.
You need to go through the FIR because I mean, it is not portrayed properly. Go through that gist of the case. No, the order 4/2.
But if your lordship sees the order,
No,
kindly.
no, that order that has been passed 4/2/2026
Yes, my lord.
from the gist can't make out.
Yes, my lord. Paragraph 5, then my lord, your lordship have to go, my lord, paragraph 5, my lord, page 5, my lord, page 5, paragraph 6, my lord,
Page 5.
page 5, paragraph 6. The petitioner most humbly submits that after arrest of the petitioner, the dispute between the parties have amicably settled under the intervention of the elderly person of the locality, and the money which was paid by the informant.
No. I was talking about the FIR.
FIR,
What was the allegation exactly? that they have extorted some money.
Yes, my lord. And they possess as a my lord income tax officer,
Income
my
tax,
lord. That was the,
okay, you're right, I mean, extorted some money. Hmm. As income tax officer, they written, na? Okay, then you write, in terms of the Biden order dated 4/2/2026, this, the coordinate bench of this court has already granted interim bail to the accused applicant, and accordingly, the accused applicant, accordingly, it is submitted that the accused applicant has already appeared with the investigating officer. Full stop. Case study in the instant case has been submitted and before this court, and that has been perused, and uh, and it is seen that some certain amount which has been which was supposed to be which was alleged to have been extorted has already been paid to the informant. Full stop. Taking into account the aforesaid facts and facts and the fact that no objection has been raised by the learned counsel appearing for the informant. Discourse of the considered opinion that the interim protection granted to the accused applicant by death order dated 4/2/2026 is made absolute. In terms of the aforesaid order, this instant bail application is disposed of.
I'm obliged.
Yeah, did you?
Item number 8, timing method.
But in this case, we are appearing as legal aid counsel. The petitioner before your lordship is a life convict, my lord. He has completed, my lord, 21 years of imprisonment, my lord. Pursuant to the judgment, my lord, that has been passed by the
So conviction was for life.
my lord,
It is for life. It is for life.
under 302, my lord.
And how many? One person only, right?
One person
here
before your
one.
lordship,
Mm.
yes.
So he has already gone 21 years, Mr. Nath.
Lordship.
What is to be done?
But at this stage, kindly give me some time. Let me take the instruction, Lord.
Okay. Heard Mr. B.K. Sen, the learned legal aid counsel appearing for the petitioner. Also heard Mr. D.K. Nath, the learned senior government advocate, government of Assam. Full stop. This is an application. This is an application under Article 226 of the Constitution of India. Constitution of India, whereby the accused, whereby the petitioner is seeking release from jail, as he has already spent more than 21 years against the judgment and order dated 8/2/2009 passed by the additional session judge, FTC Biswanath Charlie in sessions case number 14 of 2007 under section 302 stroke 201, whereby he was convicted under section 302
Page 20, my lord, paragraph 27.
and sentenced for rigorous imprisonment for life and a fine of ₹500, in default of fine. In default of fine, simple imprisonment for 60 days. Full stop. Late notice be issued. Next, late notice be issued. Notice be issued to the respondents. Full stop. However, since the learned senior government advocate accepts notice on behalf of all the respondents, formal notice is dispensed with. However, formal notice dispensed with, extra copies to be served, on the learned senior government advocate within 2 days of passing of this order. Let the matter be listed on
Let it be after 3 weeks.
after
3 weeks.
3 weeks.
3 weeks.
Okay. Let the matter be listed after 3 weeks.
No.
Supreme Court, Honorable Supreme Court has laid down in recent judgment, my lord, with regard to the, my lord, release of the convicts, life convicts, my lord, who has completed the, my lord, imprisonment for a period of 20 years.
Yeah, that is there. That's why, I mean, he will take
Yes,
his, let him take his
some
instructions.
Guidelines are there, my lord.
So in fact,
Now, my lord, the state has to, my lord, a response. That
there is
my
a,
lord, has to
there
take.
is a PIL pending. A Somoto case has been registered by this honorable court as regard the revision policy of the state. There we have filed an affidavit. I'm privy to that case. 25, page number 25 in this case, my lord, it was placed before the review committee I have seen, and it was deferred in 2024. It was deferred for 2 years. So considering the offense of the person, my lord, I'll take the instruction. I'll come up, my lord.
There was a consideration in the case.
Yes, page 25.
Okay.
Page number 25.
my lord, deferred
It
by
was-
the review committee, my lord. That is under challenge.
No, correct. Now, I mean, they are answerable, so they will give answer.
Lord, we'll
Let them
answer.
respond, my lord.
Yes, we'll answer.
They are answerable because we have been kept inside for 21 years, so they are answerable. That's why he is taking some time.
Fine.
Let him answer.
Lord.
I am obliged.
Oh.
24.
Ma'am, please, your lordship, 31 days, 56 days behind the bar, lordship, independent charges has been filed. Regarding that, they had a love affair and lordship, thereafter they eloped for getting married, lordship. This is the, yes, and the FIR lordship will find on page 9, lordship.
Charge sheet filed on
Lo-
21.
Charges were filed under the same section, lordship, 137(2) and 144, lordship. And moreover, lordship, I have checked the statement of the victim from the TCR, lordship, that she does not say regarding force, lordship. She herself came on the phone call to that particular accused person, lordship, as he was one of her friends.
What is the stage now?
Stage is my lord, committal court, my lord, send it for my lord, committal is made, my lord, is committed to my lord session, this court, my lord. And my lord, that is the age of the victim is, my lord, on that
17.
particular 17 years, 2 months, 4 days. And the accused age is 23 years about. Though, my lord, at this stage, my lord, that POCSO section is not there, my lord. Maybe later, but maybe edit in the session. But police didn't, my lord, edit, my lord, section of POCSO.
Charge sheet was not filed against POCSO.
Not,
Oh, no,
my-
Lord.
not, my lord. That 183 statements is there, my lord.
Basically, the sections are regarding kidnapping.
This cannot be read.
183, next page is not
Next
legible,
page before the
not,
police
not legible. My lord, only that is the last line, that is in the first page, my lord, 183 statement, that indication is there. And in medical examination, she refused.
There was some attempt on, I mean,
My lord.
attempt has been done.
Next date is fixed 23/2/2026 before the trial court. So 23
there-
22 only.
Yeah,
It's not
witness is
available in the
there.
record.
Hmm?
23/2 order is not available in the record.
Heard Mr. S. Munir, let him go. S. Munir, the learned counsel appearing for the accused applicant, also heard Mr.
K. Boyson.
K. Boyson, the learned APP for the state. This is an application under so and so. Then you write. An FIR was lodged on 1/1/2026. By the informant alleging that his daughter of 17 years left their residence on 1/1/2026, but she did not return home. It was also alleged that her mobile phone was switched off. The family of the victim girl tried to search for her, but they could not locate her. Therefore, they filed this missing report, the aforesaid missing report, filed the aforesaid missing report before the police. Full stop. When the girl was recovered, that day only, no?
The day itself, okay? No, not on the FIR date, Lordship, next date. 6/1, Lordship.
From where do I get it?
From the forwarding report, Lordship.
Where is it? Page?
Page 16, Lordship.
Page 16.
That page 17 of our report. That the region of arrest, Lordship, they arrested court red-handed by Fatah Silambari while he was trying to commit the offense.
The forwarding report reveals that the accused as well as the minor girl, the minor victim girl of, minor victim girl were recovered by the police on the next date, that is on.
And sorry, Lordship, page 18 also the order, the victim girl has been produced before the 7/1, victim girl was produced before the court. The next page, page 18.
Reveals that the accused reveals that the minor girl along with the accused applicant were recovered by the police, and the girl was produced before the magistrate's court. Before the magistrate's court. No, before the SDGM, not right magistrate, before the SDGM, in bracket M, Bisney, on 7/1/2026. Full stop. The learned counsel appearing for the accused applicant submits that the police has filed a charge sheet in the instant matter wherein 6 PWs have been listed, and the matter is in the committal stage. In the committal stage, full stop. He submits that the accused applicant is a 23 years old boy who was in relationship with the victim girls and the victim girl voluntarily went with him without any force or coercion. Full stop. He further states, he further submits that there was no sexual assault on the victim girl by the accused applicant, and he is behind the bars for last 56 days. He submits that since the trial will take a considerable time, and taking into account the length of detention, the accused applicant should be allowed to go on bail at this stage. Full stop. Mr. K. Baishal, an APP, on the other hand, submits that the victim girl as well as informant is yet to be examined in the instant case, and therefore at this stage, if the accused applicant is released on bail, he may try to influence the victim as well as his family, and therefore opposes the bail at this stage. Full stop. This court has gone through the case records received from the trial court, received from
CDM.
received from SDJM, SDJM, SDJM business, and also heard the submissions made by the respective counsel appearing for the parties. After taking into consideration of the fact of allegation as made in the FIR, as well as the materials brought before this court is of the considered opinion that at this stage, since the trial is yet to start and the accused applicant has already spent a considerable time, that is 56 days, inside the jail, should be allowed to go on bail. Accordingly, it is directed that the accused applicant shall be released on bail in furnishing of a bail bond of rupees 50,000, rupees 30,000 with a surety of like nature to the satisfaction of the SDGM business, subject to the following conditions: that the accused applicant shall appear before the trial court as and when required. Full stop. That the accused applicant shall not try to influence any evidence or witnesses that may be involved in the case. Then you write, the accused applicant shall not try to contact the victim girl as well as the family members of the victim girl till the completion of the trial. In terms of the aforesaid direction, the instant bail application is disposed of.
Much obliged. Much.
27 and 28, 27 and 28 arising out of same FIR, Lordship. And page 12 is the FIR. There on the basis of information, Lordship, the police went to the railway station, and from there, Lordship, they apprehended 3 persons. And in middle portion, your Lordship will find, they say, Lordship, 3 persons were carrying backpack, and accordingly, they recovered 58.392 kgs of ganja, Lordship. But they have not specified from whom those quantities were recovered, Lordship. And they have not also not mentioned what was the individual quantity which was recovered from the.
It was recovered from one bag.
No, one bag. One person was carrying one bag. Who was that person? Because here 3 persons were there. Your Lordship will find page 13. 3 persons' names are there.
Correct, 3 persons, and they were moving together. So it has to be corrected from 1 person only.
So that's Lordship, they have to specify, because Lordship, they have added section 29. And if 29 is there, who abetted and who was carrying, there has to be specific finding to that aspect. On merit, Lordship, that is there.
Specific finding will come after.
So they have completed their investigation. They have filed their charge sheet. Even in charge sheet also they have to file. And apart from that aspect, Lordship, that 3 numbers are big. Just I am 3 numbers, page 16. page 16, serial 2, 3 numbers of signature bag, blue and white cotton bag.
Page 16,
Page 16, that's serial number 2,
3 numbers of signature bag.
bag, blue and cotton. So 3 numbers of bag. Total 3 bags.
No, what is signature?
Maybe
Blue
some
and white
company
cotton.
name.
Okay, blue and white cotton bag.
Oh.
And one black color backpack.
So total 4 bag. And 3 persons are there. All are carrying money.
4 bags or 3 bags?
3 numbers of signature bag, 1 bag color
The
backpack.
4 bags are there, from which bag it was recovered, there has to be specific finding. And apart from the merit lordship, that 48 notice was not served to the family members of the accused person's lordship. Here, I'm representing 2 accused persons. One was declared juvenile, and 1 and 2 is before your accused number 1 and 2 before your lordship. Now, page 16, last paragraph, your lordship may kindly see. Page 16, last paragraph. The grounds of arrest has been communicated to the arrested, to the accused person by serving notice under section 47 BNSS, and under section 48 BNSS could not serve to their family members, relatives. So I sent a WT message to their local police stations and inform over telephone accused persons, namely so and so. Those phone numbers are there, Lordship. And the accused persons, namely so and so mother, inform his mother, and accused Prince Kumar. This is the grounds, Lordship. Now, Lordship may kindly peruse the records, Lordship, and that WT message, Lordship, I have flag mark, Lordship, in green color. It was addressed to
Record.
Malat, this is the record. It was addressed to the police officials. Police.
That is mandatory, no? I mean, jurisdictional police officer has to be given
served, but there
message.
has to be subsequent
That, I mean,
communication that it was
two things you need to do. One is the family member, other was the jurisdictional police officer. So jurisdictional police officer W2 message they have given, and telephonically they have intimated the wife.
Sure.
So now it will see whether it has been substantially complied or not.
Malat, that message, Malat, flag mark, the green flag, Malat, WT message. And the order of production, Malat, on 23/7. That is also a flag mark. That is to the concerned police station.
And Lordship, that during production, Lordship, remand order that they were given time for submitting documents, whether it was subsequently filed before the to the family members or not. A specific finding is there in the remand order, Lordship, to that aspect.
Prince Kumar is what, the juvenile?
He is declared juvenile.
But as far as these two people, they have been informed, over the phone.
No, but that aspect, your lordship has already dealt in.
No, that has been informed by the accused person on their, to his mother and to
Mother.
his wife, to two persons,
One,
mother and wife.
one wife and one mother.
That is on record.
No, that
And
lordship, the
other
information-
grounds of information, everything has been explained.
So grounds of arrest, lordship, that probably was not explained.
Yeah, it is written there and telephonically, it was not the police who has intimated. He himself intimated with the over the phone.
No, just I'm reading that part, lordship. The local police and inform over telephone accused persons namely so and so. That grounds of arrest informing lordship, that your lordship have already dealt. with.
Mr. Parasar, arrest memo also doesn't contain any signature.
36.
Yeah, this court is consistently, holding that. The 36 and 36, if 36 is not complied, then difficult.
But regarding their 48 wife and mother info, the telephone number also specifically given the telephone. These are the two telephone.
And that is correct, but what about arrest memo?
36 only signature of the officer and the accused.
No signature. That is a statutory, this thing. You'll have to allow it to find. Because 48, 47 compliance over the phone and taking into account other things, grounds properly given, an acknowledgement has been made stating that details have been intimated over the phone. That can be, that is, taken as compliance.
But in
Substantial
Mr. Kumar's
complaint.
case, lordship, it is said that in writing it has to be there.
No, writing is also, if the
Then
notice is.
Initially, they can communicate with the.
See, writing, it cannot be sent to Manipur, no? So W2 message has been sent
Yes,
to the jurisdiction police officer. And over the phone, it has been given, and a written communication will be sent. That is what.
So from the decision lordship, a written communication was not there. That is what I was submitting lordship for this honorable court. That they have given the WT message. In fact, even if your lordship peruses the WT message, it contains only case number lordship, and that grounds were not there in that WT message lordship. Regarding that lordship, our High Court already dealt with the issue lordship. That there has to be grounds of arrest, even WT message is there. Merely posting that case number and the sections will not suffice lordship. That copy of the WT message is also there in the record. It says only the case number.
Heard, I will have to allow him. Heard, Mr.
There should be, as per the act, there should be a nodal officer in each police station, and he has to be communicated. He has to serve the notice. Then scan copy, he can take a printout and serve it.
No, that is the purpose actually. That is the purpose of giving to the jurisdictional police officer. But they do not do it. They should immediately go and serve it and take the acknowledgement and put it on record. But that is not happening. The problem is that. Heard Mr. Ahmed, the counsel, preparing for the accused applicants. Also heard Mr. K.K. Parasar, Leonard APP for the state. Then right, this is an application under so and so. The gist of the case, as narrated in the FIR, is that one WSI, namely Gauhati Fukan of Patrakandi Police Station, lodged an FIR on 22/7/2024 before the OC, Pathakandi Police Station, alleging inter alia that on the same day about 4:12 p.m., an information was received about 3 persons transporting ganja near Buiragram, Baraigram railway station. And on receipt of such information, the informant and along with her staff reached Boraigram railway station at 4:40 p.m. And after waiting some time, 3 persons, 3 persons, including the 2 accused applicants, have been arrested. On search, the police team recovered 29 packets of 29 packets in 29 packets totaling to 58.392 kgs of ganja. Next, on completion of the investigation, the investigating authority has submitted the charge sheet on 30/8/2025, wherein 9 PWs have been named. Full stop. The learned counsel appearing for the accused applicant submits that while arresting the accused applicants, the mandates of section 36 as well as 48 of BNSS was not complied with. Therefore, taking into account the ratios laid down in Katana of cases decided by the Honorable Apex Court, including the case of Vihan Kumar versus State of Haryana and another, and DK Basu. What was the citation of DK Basu? And
DK Basu 1997,
DK Basu versus
DK Basu versus State of West Bengal.
West Bengal, reported in
1997, 1 SCC 416.
416. That violation of section 36 and 48 shall give indefeasible rights to the accused applicants to be released on bail. Full stop. The learned Mr. K.K. Parasar, the learned APP, on the other hand, submits that section 36, section 48 notice has been duly complied with as WT as a WT message to the jurisdictional police officer was sent immediately. In addition to the fact that the accused applicants were allowed to intimate about their arrest on their given mobile phones to their family members. Therefore, he submits that there is substantial compliance of section 48 of BNSS in the instant case. Full stop. 36.
36
However, the learned APP very fairly submitted that from the case record, the signatures of the accused persons could not be found. Signatures of any witness, witness could not be found in the arrest memo prepared at the time of their arrest. Full stop. In view of the aforesaid, this, no, right, cut it there, because this court has reduced the scan copy of the trial court record which has been produced before this court. Full stop. It is found that though the arrest memo was prepared, no signature of any witness or any family member of the accused applicants could be found in those arrest memos prepared under section 36 of BNSS. Full stop. It is also seen from the records that though there is a mention of allowing the accused applicants to speak to their family members, respective family members over the phone, no written notice under section 48 could be located in the case record. Full stop. Full stop. In addition, additionally, the WT message does not, the WT messages do not contain any grounds of arrest of the accused applicants. Full stop. The non-conformity of the provisions, a non-conformity of statutory provisions under section 36 and 48 of the BNSS is fatal in an arrest without warrant. Full stop. In view of the aforesaid discussions and discussions on the materials available on record, this court is of the considered opinion that the mandates of section 36 and 48 of BNSS were not complied with by the arresting authority while arresting the accused applicants, which go to the root of the process of arresting and making the same violative of Article 21 and 22(1) of the Constitution of India. Accordingly, the arrest of the accused applicants become illegal, being against the fundamental rights guaranteed by the Constitution of India. Next paragraph. In consideration of the whole matter available before this court directs that the accused applicants shall be allowed to go on bail on furnishing of bail bond of ₹1 lakh with 2 sureties of like amount to the satisfaction of the special judge
Sribhumi.
Sribhumi, subject to the following conditions. The accused applicants shall cooperate in the trial of special NDPS case number 49/2025. The accused applicants shall appear before the trial court as and when so required by the trial court. That the accused applicant shall not directly or indirectly make any inducement, threat or promise to any person who may be acquainted with the facts of the case, so as to dissuade such person from disclosing such facts before the trial court in the trial pending against the accused applicants. Then you write, the accused applicants shall provide their contact details, including photocopies of their Aadhaar cards, driving licenses, PAN cards, mobile phone numbers, and other contact details before the trial court. That the accused applicant shall not commit any offense while on bail. In view of the aforesaid direction, the instant bail applications then disposed of as allowed.
Materials found there, this common order or individual order, 2 applications are there, 27 and 28. Date of arrest, everything is same. All are
Same, I mean, you do one thing.
Only name are different.
I have given accused applicants, you make it accused applicant 1 and here 1. Two orders, same order will go. You say it.
Date of arrest is Lordship 23/7/25.
Same,
Same.
same, all same otherwise.
Well, in Lordship, item number 27, due to inadvertent mistake in cost title, I have written 23/9 Lordship instead of 23/7.
Same, matlab, forwarding report same.
Outline.
Itu yang ke semua. Macam mana? Consequently, this court is of the considered opinion that the instant case needs to be remanded to the government authorities, particularly the respondent number 3, to conduct an inquiry into whether the subject of English had prior government concurrence or not. They must examine the document bearing number so-and-so dated 31/1995, submitted by the petitioner along with the instant petition to verify its correctness. Upon completion of the inquiry, a report must be submitted, and after receiving the report, respondent number 3 shall consider the case based on the findings of the inquiry in accordance with law. If the petitioner's rejection was solely due to the alleged no government concurrence and it is found to be incorrect, the government must reconsider his case and the petitioner should be treated as one of the targeted candidates as per the office memorandum dated 17/7/2004 issued by the Secretary to the Government of Assam Education Department, since the petitioner was duly appointed to a non-sanctioned post on 15/12/2003, which is prior to both the cabinet decision as well as the aforementioned office memorandum. Accordingly, in that event, the petitioner shall be eligible for consequential benefits. Therefore, the respondent number 3, on receipt of this copy of the judgment and order, within a period of 2 months shall make the inquiry and prepare a report, and thereafter, after considering the report, within a period of 1 month shall pass a speaking reasoned order in consideration of the case of the petitioner. Accordingly, this petition is disposed of.
My lord, I beg to mention for listing, my lord. My lord,
Don't mention when, off mention hours.
matter listed tomorrow, my lord. That's all.
Later on, later on. Yes.
Yes, may
Yes,
please, your
Mr.
lordship.
Yes,
My lord, the TCR was called for, TCR has been received, my lord.
yes.
And they are solely on the ground praying for default bail, my lord, which has been rejected by the learned special court, my lord.
Default belt was rejected.
Yes, my lord.
Default belt was rejected. Why? On what ground?
My lord, on the ground that it was filed prior to the filing of the application, prior to the accused avail that indefeasible right, my lord. So basically, my lord, they are assailing that order. So in my humble understanding, my lord, they ought to have challenged that impugn order, my lord. The order passed by the learned court below, my lord. It's a trial court, my lord. My lord will find the impugn order in page number Annexer 12, page number 36, my lord.
Annexer?
Annexer 12, Annexer 11, my lord, page number 36. Here your lordship will find in para 4, my lord. The learned special PP has submitted that on completion of investigation, the IO has submitted charge sheet against the accused person by charge sheet number so and so, dated 29/11/2025, and the same is received by this court on 1/12/2025. It is submitted that present bail application is filed on 2/12/2025 after submission of the charge sheet, and the accused person is not entitled for any benefit of default bail under section 187, subsection 3 of BNSS. It is further submitted that as there is charge sheet against the accused person, the court may take cognizance and trial may be proceed against the accused. I have carefully perused the record and seen that the IO has submitted charge sheet against the accused person before any application filed by the accused person. As such, the accused person is not entitled for any relief of default bail. If it is further observed that this is the third bail application filed for release of accused, so and so.
What is his submission, petitioner submission?
Lordship, what happened in this case is that we have filed the default application on 2nd of December. And before filing this application, we had made inquiries in GD room as well as in filing section. And they have informed us that there is no charge sheet has been filed. And on the very next day, it was informed that after filing of the default bail in the evening hours, the police had filed the charge sheet. Now, Your Lordship, now when this order is, now in the impugned order in paragraph 4, it is mentioned that the same has been received by the court on 1/12/2025. However, Your Lordship, I beg to mention that on 1st December 2025, the court was closed. The High Court as well as the trial court was closed. So therefore, it is not possible that it would have received on that very day. It was closed on the occasion of Indigenous Faith Day, Lordship. So, and in practice also what happens, Lordship, is that before, whenever we file default bail, in the filing section, it is confirmed whether the charge sheet has been arrived or not. If the charge sheet has not been received, only then default bail is accepted therein.
Mr.
And
P,
Lordship, I also beg,
Mr.
I
PB,
also beg to mention.
Another
Yes, my
thing
lord.
is that, I think only receipt of the charge sheet will not do. That has to be put up. That has to be seen
Yes,
by
Lordship.
the presiding officer of the trial court. Whether that
Yes,
has
Lordship.
been done or not, that has to be seen.
Yes, my lord, that will be there in the record, my lord.
See, the charge sheet doesn't reveal that the charge sheet was seen by the court.
Lordship.
Order, my lord.
No, it was only stated that received by this court. But
Yes,
receiving
Lordship.
will not
Yes.
do. There is a judgment passed by a coordinate bench of this court saying that
Okay.
the receipt of the charge sheet will not do anything. It has to be seen by the court where it has been submitted. Once it is seen, then only it will be deemed as effectively submitted. So that,
Okay.
Mr. Counsel, you don't have the judgment of Gauhati
No,
High
no.
Court? You don't
No,
have
no,
it?
Lordship. No, I don't have it, Lordship.
You'll have to find
But-
out that. You'll have to find out, then we'll have to examine that. You'll have to examine that. Go through that and place before the court. There is a judgment of this court.
Lordship, in that case, this matter may be listed of 2nd of the March.
Yes, that, 2nd of March, this court will be there in Arunachal.
Yes, my lord.
Yes, so it may be listed,
We'll take it up at that point of time. You check that judgment.
Lordship.
Judgment. Yes. You just write it down, the number of the case. Has it been reported?
Yes, it is reported, but I have the number, BA number.
Okay, it's a reported case, but you take down the bail number, application number.
BA number 195.
Yes, my lord.
BA number 1958
2022.
2022. Okay.
Okay, madam.
You find out the judgment and place it before, place that before the court when the court will be sitting on 2nd there. So we are
Okay,
posting
ma'am.
this case on 2nd, okay? You are Mr. H.
Lordship.
Thai. H. Thai, Learned Counsel, appearing for the
H.
accused.
Ape.
Huh? H. What is your name, please?
H. Ape, Lordship. H. Ape.
And Mr. APP, what is it? Let the matter be listed on
2nd, my lord.
232026. Before the ordinance bench. Okay.
Obliged, my lord.
And what is this case all about? That
The other one. Yes,
who has submitted this?
yeah,
The petitioner side, my lord.
Lordship, I have. Lordship, in that case, the charge sheet was, the bail application was filed on 8:53 AM and then thereafter charge sheet was filed later on 11:15 AM. So even an hour difference that ensures that,
Okay, we'll examine this.
Lordship.
Obliged. Obliged, my lord.
29.
Yes.
May I please, Lord? The targeted case, my lord. FIR, my lord, case 14. Is a driver by profession, my lord. Contraband was found under the seat, my lord.
Hmm?
Contraband was found, my lord, in the truck, my lord.
Hmm. Yes.
FIR case 14.
Mr. Borwa, see all these NDPS cases, Mr. Boyster also, on NDPS cases, while seizing the contraband material, already witnesses are there. Correct. And but in spite of that, while the arrest memo is prepared, no witness signature is given. You already have, because
This is to the Caesar, this is different, my lord.
correct, you have to have independent witnesses, no? So those signatures could have, one signature could be taken.
Yes, sir.
You don't need to have a different,
And
different
already
witness
two
for this.
witnesses are there.
Already two independent
Yes,
witnesses are
yes,
there.
ma'am.
Still you don't take in, I mean, this thing.
Yes,
That, I mean, anyways.
And seizure was also not followed by, my lord, the rules, my lord. Rule 3, my lord. Rule 3 and 10, my lord, not followed in this case, my lord.
Which is not followed?
Rule 3 and 10, my lord.
What is rule 3 and 10? You read that portion of the FIR.
Entire FIR, my lord.
No, that portion of when the seizure was made.
Page 15, my lord.
Yes, read.
Thereafter, I, SI so-and-so, in presence of witnesses, conducted a self-search before initiating the search of the intercepted vehicle and the body of the detained persons. The same procedure was also carried out for the team members. This was done after maintaining formalities of the search and to demonstrate that no incriminating substance were present on me or the team. Thereafter, I serve a notice to the apprehended persons, namely so-and-so and so-and-so under section 50 NDPS Act. On receipt of the consent from the driver and handyman of the intercepted vehicle, I conduct a search of the intercepted vehicle and the body of the driver and handyman. During search, a cotton bag red in color was found beneath the seat, where contained 20 numbers of shop boxes containing suspected to be heroin and 2 mobile phones belonging to the driver and handyman were also found. During search, recovered 22 shop box were marked as P1 to P22. Thereafter, each shop box were weighed at the police station using the digital weighting machine belonging to the Vasishtha PS in presence of the above mentioned witnesses. Then, my lord, it was weighted, my lord, total 295.46 gram, along with the box, my lord. Then the whole recovered item, along with suspected heroin, were fully seized at 12:30 p.m. as per seizure list in presence of witnesses at the PO. That is Lalmati NS so-and-so, in front of so-and-so under Vasishtha police station. The suspected recovered heroin was packed and sealed in presence of witnesses at the PO itself. Further, the suspected heroin was tested during through drugs.
Yes, what is that procedure which has not been followed?
Now, subsequently, my lord, this regarding sampling also, my lord, sampling has been, my lord, in section 10, my lord, rule 10.
No, where is the sampling has been mentioned here?
My lord, here in the record, my lord, because case has been charge sheeted, my lord, then copy has been served.
Mm.
And in the copy, my lord, TCR, my lord, it was found that these rules has not been followed, my lord.
And how you saw how?
My lord, the my lord box as well as my lord suspected my lord NDPS totally, my lord, are not separated and not weighted separately, and it was not a bundle as per my lord section rule 10. Rule 10 says, my lord, if there is more than 10, my lord, then it should be contained, my lord, maximum 10 boxes, my lord, and sample should be taken from each, and then, my lord, it will send.
No, from where you are saying that it has not been done?
But they have given, my lord, copy, my lord. They have marked as P1 to P22.
Correct. They have done it. Then
there is no separate, my lord, bundles, my lord.
what separate bundles?
But as per
These are in soap boxes.
When
What
they, my lord,
separate
take the
bundles?
sample, my lord,
It cannot be bundled up.
no, when, my lord, they take the sample, my lord, from each of the box, my lord, then it should be taken from each.
From where you're saying so? See, after the seizure, it will be taken to the magistrate.
Magistrate, my lord.
For the magistrate, they will do the weighing, they will do the sampling. And from where you are saying that that hasn't been done?
Lord, in the
You are only saying that, those, separately not weighted.
lordship.
That need not be done at the place of occurrence itself.
And in the
Is there anything, in the procedure saying that that has to be done at the place of occurrence only?
in the record also, my lord.
See, these are the issues that will be decided before the trial court.
Now,
Okay.
my lord, case has been charged, charge has been framed, my lord.
Correct. Trial court will
And-
decide this.
And he is in custody, my lord, for 267 days.
Yes.
And, my lord, quantity, my lord, as per sampling, my lord, 2.8, 285 gram,
The 285 grams, these soap cases are, what is the commercial quantity?
250 gram, my lord,
Yours is
285.
285.
Marginal, the case of marginal, my lord. Wait,
It is 295 grams.
at the time of, my lord, in the place of occurrence, while it was sampling, my lord, it was found to be, my lord, 285.
No, 285 without the soap boxes or boxes?
Then with box, my lord.
Top box is 295.
It is 295 gram without the soap cases, soap boxes.
Or in the, my lord, sampling, my lord, it is sample packed.
No, no, it is there in the final charge sheet. It is 295.46 grams without soap boxes. And I mean, and in the FIR, it is not stated whether it's with or without soap boxes. So we'll have to go by this charge sheet. What is that?
Record given to us, my lord.
No, this charge sheet says so.
After, my lord, even, my lord, may I submit, my lord, even if, my lord, the contention is not 295 and it is 285, then it is also, my lord, more than commercial quantity. As per, my lord, commercial quantity, it is, my lord, 250, my lord. So, my lord, if
Yeah, understood. That is understood. His contention is their soap boxes are, I mean, not separated. But it is without soap boxes, Mr. Ali. FIR doesn't say that the weight was done with the soap boxes. Search it is, it has been clearly mentioned.
In the inventory, my lord,
Yes.
285, my lord, with plastic.
Yes, sir.
Where is the inventory? Wait 1 second. Here it is said, I mean, this is scissor list, Sarsen scissor list. Sarsen scissor list says 295.48 grams without soap boxes. Otherwise also it will not be more, it will not be lesser than 250 grams.
It is a marginal higher side. Then, and this, my lord, he has no, my lord, criminal records, my lord.
No,
And
no,
he
there
said-
are, I mean, there are materials against you. There are materials against you.
And 267 days, my lord.
267 days in this kind of offenses thing. Not Mr. R. Ali, the learned counsel appearing for the accused applicant. Also heard Mr. K. Boyso, the learned APE for the state. This is an application on the students. An FIR was lodged on 462025, alleging that on receipt of secret information on 462025, the informant along with the police team apprehended one Maruti Suzuki Arena vehicle during a vehicle which was a vehicle registered as A01 LC 1253, which was coming towards Lokra. It was alleged that on intercepting the vehicle, the driver and handyman were apprehended, and while being questioned, they revealed that a cotton bag beneath the seat was hidden, uh, full stop. On search of the bag, the police recovered 22 numbers of soap boxes containing suspected heroin amounting to 295.46 grams, full stop. On receipt of the FIR, the police registered Bosista PS case number 313/2025 under section 21 in bracket capital C stroke 25 stroke 29 NDPS Act 1985. On completion of the investigation, the police filed the charge sheet. Police filed a charge sheet by 394 by charge sheet number 394 stroke 2 stroke 25 dated 11/9/2025 against the accused persons, including the accused applicant. Full stop. Next, you write the learned counsel appearing for the accused applicant submits that the accused applicant is behind the bars for how many days?
267.
267 days. And the alleged seizure of heroin is marginally higher than the commercial quantity. Full stop. He submits that since the accused applicant has already spent considerable time behind the bars and the amount seized being a marginal is being a little bit more than the commercial quantity, at this stage his further detention may not be required and therefore he should be released on bail. Full stop. A learned APP, on the other hand, opposes the bail application, stating stating that the rigors of section 37 of NDPS Act will be applicable in the instant case. Therefore, at this stage, the accused applicant should not be granted bail. The trial court record of NDPS case number 308/2025 corresponding to Bosista PS case number 313/2025 is produced before this court, and the same has been produced by this court. On perusal of the materials brought before this court, including the charge sheet, it is revealed that the quantity which was recovered and seized amounts to 295.46 grams without the soap boxes. And it is also seen that there are records and statements that the accused applicants are habitual offenders and has been involved in drug trade for a long time. Full stop. Taking into account the whole aspects of the matter in its entirety, and following the rigors of section 37 of the NDPS Act, this court is not of the opinion that the accused applicant should be granted bail at this stage. Accordingly, the instant bail application is rejected.
Okay.
May it please the Lordship. 483 application, my lord, and FIR is at page 13. And my lord,
Yeah, but tablets, 1,000, okay, how much?
recovered quantity, my lord. It's a matter under Special Act, my lord, registered under section 22C and 29.
22 is a commercial quantity.
Yes, my lord.
Total weight is 1093 grams.
Yes, my lord. That is recovered from two persons, my lord, namely Ahmed Hussain
Hmm.
and my lord, second person is Ali Hussain. It is alleged, my lord.
Ahmad Hussain, Ali Hussain.
Yes, ma'am.
And who is Kamal Chaudhary? Kamaluddin Chaudhary?
Yes, madam.
Kamaluddin Chaudhary.
Yes, madam.
Yes.
During the spot interrogation, Lordship will find the allegation, page 13, Lordship is having, my lord.
Page 13.
Yes, my lord.
Hmm.
May I just read the relevant part, one is the last paragraph.
1 second. Page 13, yes.
May I just read, my lord, before the last paragraph, my lord.
Hmm.
Before starting the search process, during the preliminary interrogation on the spot, the detained person identified themselves, Ahmad Hussain, son of so-and-so, number 2, Ali Hussain, place so-and-so, and also they stated that the drugs belongs to the drug business family, Joshimuddin, Najimuddin, and Montumia. So they named, my lord, 3 persons. It is stated that they have given them the contraband, my lord, to deliver. Now, my lord, that's page 14, where my lord, my page 14, man. Further, they revealed and admitted that they were transporting the tablets from the house of so-and-so, that the 3 names, pilot, which were supposed to be received by the present petitioner, Kamal.
Hmm.
So this is the allegation, my lord, against the present petitioner. And my lord.
Yes, then forwarding report.
And forwarding the page, it starts from page 17, my lord.
Hmm.
I was forwarded to the judicial custody 16/5/2025, and since then I'm in, my lord, custody.
The reasons,
Reasons, my lord. Reasons, my lord. The red-handed accused person stated seized drugs are supposed to be received by the accused, my lord. The co-accused of the case are yet to be arrested. If the accused are not arrested, may hamper and as the accused trying to abscond, that is not correct, my lord. I was at my home. As per statement, source of drugs, that is, my lord. Now, my lord, the charge sheet has already been laid in this case.
Hmm.
And after filing of the charge sheet, my lord, the material which remains against the present petitioner is the confessional statement. And after the investigation, my lord, the investigation officers also exonerated the other 3 accused persons, my lord, that were suppose that as per the statement made by the apprehended accused person, that they gave the contrabands, my lord. That 3 names, lordship is remembered, my lord. Their name appears, my lord, in page 15, my lord, as an accused, 3, 4, and 5. Yeah, they are also a fan. I'm at serial number, the present petitioner is serial number 6.
Ahmad Hussain and
Yes,
Ali Hussain are the people from where received. I mean, they recovered.
Yes, ma'am.
So Kamaluddin Chaudhary is the person was to be received,
Exactly.
who's supposed to receive this.
Yes, ma'am.
And Mantu Mia,
And my lord, 3, 4, as per the statement of the apprehended accused person, 3, 4, and 5 gave them the contraband.
but they didn't find any evidence against them.
Yes, ma'am.
Hmm.
So they were examined with charge sheet. But what materials, after even filing the charge sheet also, my lord, the material against the present petitioner is the statement as well as, my lord, page 32, if lordship. Page 32, my lord. Now, they say during investigation, they found that I have given them the contraband, my lord.
But you have been, I mean, it is found that they were there, I mean, both of you, I mean, you communicated over the phone.
No, no, my lord, there is no such, my lord, CDR or anything has been relied on by the prosecution, my lord, in the present case, which lordship will find, my lord. If Lordship peruses page 26, my lord, particulars of documents cited and relied upon by the.
The mobile phone number was mobile phone seized, mobile CDR
Mobile
was
C-
received.
yes.
CDR, it was found that you have been called.
Not my CDR, it was not found that I called, my lord. It was
They have
ve-
called you.
It was, my lord, during investigation, we were within the tower location, my lord. The lordship knows that, my lord, in tower location, there has been a number of mobile phones are operating, my lord. Merely because tower locations are there based on such, my lord, material. In fact, my lord, there are our High Court judgments, my lord, where there was direct communication, even though our High Court held that, my lord, it cannot be assumed that those communications were made in respect of the offense, my lord. In my respectful submission, my lord, apart from that statement, my lord, there is no other direct evidence which linked the present petitioner, my lord.
Yes, Mr. Borua.
My lord. Now, my lord, we have received a scan copy of the report, my lord. And from the, my lord, material, my lord, yes, my lord, it is implicated, my lord, he has been implicated by the arrested person, accused person, my lord, from whom, my lord, this commercial quantity of contraband was recovered, my lord. So, lordship may kindly come to page number 31, my lord. This is a part of the surgery. Page
31 of?
31, paragraph number 10, my lord, last paragraph.
31 of?
31 of bail application.
Bail application.
Bail application.
Yes.
Para number 10, my lord. During the lodges of FIR, accused Jasimuddin, accused Nazimuddin, then my lord, another accused person, Montu Mia, son of so-and-so, names were added as FIR name accused person, but my lord, these accused persons were not charge sheeted, my lord, later on, my lord. Named accused person based on primary interrogation statement of Ahmad Hussain, and the second one is, my lord, Ali Hussain. From those positions, my lord,
Yes,
the
yes.
contraband was recovered.
Yes, yes.
Assam. But during investigation, it is found that, my lord, on 12/5/2025, Kamaluddin, my lord, that is the present petitioner.
Where? On?
Just below, my
Ah,
lord.
yes, yes, yes.
Gauhati.
Found that.
Yes.
Yes, Kamaluddin.
But during investigation, it is found that on 12/5/2025, Kamaluddin, son of so-and-so, resident of so-and-so, given them one cart of Yaba tablet for just the crossing border fencing. Accordingly, after putting it in a bazaar bag, they went to border for passing border fencing. But on seeing the BSF alertness, they returned from the border. But on the way at village Sadarasi, the police team apprehended them in red-handed. While they were going to border at that time, Montumia, son of so-and-so, prevented them from passing in front of their house. Hence, they thought that he informed the police about them. So they told his family members, Jasimuddin and Nazimuddin, named before police on the spot. But during investigation, there is no evidence found against them as they involved in drug selling, peddling.
So
they may
there are
continue to-
serious allegations against you.
No, my lord, it is not true, my lord.
Then, my lord, para 11, my lord.
Lordship may kindly peruse the statement made by the accused persons, my lord. That will clarify
No,
that.
no, that's test. Other than this, during investigation, it
During
was found.
it is found.
My lord, during investigation,
Now, should I rely on this or like I should not rely on this investigation? That will be trial court will decide on that.
My lord,
But at this stage, there are your direct involvement is there.
my lord,
No bail.
Lordship may kindly give us.
No. But, there is I mean, the direct involvement is alleged.
My lord, Lordship will kindly have perused, my lord, page 21. my lord.
What is that?
Page 21, what has been seized from my possession? They said that I gave them the.
No, I mean, it was not seized from you, but you were there, I mean, in the border.
No,
You
my
were
lord,
there
I
in
was
the
not
border.
there in the border, my lord. That is completely, they have, my lord, apprehended the accused person in the place called, my lord, within the town, Sadarasi area, my lord. Lordship will kindly peruse, my lord.
On 12/5/2025, Kamaluddin
Yes, my lord.
given them one karta of Yaba tablets.
Yes. It is stated in the investigate, my lord, during investigation.
So during investigation, it has come out.
My lord, there
So
has-
should I believe this or not?
my lord, there has to be some.
Should I believe this or not? That will be decided by a trial court if it is incorrect statement. But at this stage,
There has to be-
what has to be believed?
My lord, there has to be some material, my lord, taking this allegation, my lord, that I have given them or During investigation, the materials.
So
for the
investigation, this has come out that, that Yaba tablets for just crossing the border fencing. Accordingly, after putting it in a bazaar bag, they went to the border for passing the border fencing. But seeing BSF alertness, they returned from the border. But on the way at village Sadarasi, the police team apprehended them.
Malad, that has to be.
It is clear cut, I mean, this thing against you on the.
Malad, that has
No,
to
no,
be-
no, no,
Malad,
no.
kindly, Malad,
No, no, no,
kindly-
no.
kindly
No, no,
appreciate-
I will not. I will not. Heard Mr. So-and-so, the learned counsel appearing for the accused applicant. Also heard Mr. R.J. Burwa, learned APP for the state. This is an application under so-and-so. An FIR was lodged on
12/5, Malad.
12/5/2025, 25. Before the Karimganj police station, alleging inter alia that the information, an information was received that some 3-4 persons dealing with narcotic contrabands were supposed to deliver the same in Karimganj town. On receipt of such information, the police team reached the location at about 10:40 a.m. and two numbers of suspected persons who were coming towards Lucky Bazaar Road were apprehended, and the police recovered Yaba tablets totaling to about 1093 grams from one Ahmad Hussain and Ali Hussain. Full stop. On interrogation, on inquiry, they stated that the same contrabands belong to one Jasimuddin, Najimuddin, and Montu Mia, and the same was to be received or delivered to the accused applicant, namely Kamaluddin, alias Kamal Chaudhary. Full stop. On receipt of the FIR, police registered Karimganj PS case number 221/2025. After completion of the investigation, police filed the charge sheet number 249/2025 dated 22/7/2025. Full stop. Wherein 11 witnesses have been named. Full stop. The learned counsel appearing for the accused applicant submits that the accused applicant has been arrested by the police only on the basis of the confessional statement made by the two accused persons, namely Ahmad Hussain and Ali Hussain, and there is no other material was available before the police to implicate the accused applicant in the instant case. Full stop. He submits that the accused applicant is already behind the bars for how many days?
Malad, it's 9 months, 9 days. It's
9 months,
25.
9 days. And since there is no material against him other than the confessional statement, the accused applicant should be released on bail at this stage. Full stop. Mr. R.J. Burwa on the learned APP on the other hand opposed the granting of bail application, stating that his involvement is directly the involvement is apparent from the police investigation, which is available in the TCR. In the TCR, full stop. The TCR in connection with NDPS, special NDPS case number 44/2025 is produced before the court, and same is perused, full stop. It is seen that during the investigation, a direct connection of the accused applicant with the persons, namely Ahmad Ali namely Ahmad Hussain and Ali Hussain could be seen. Direct prima facie, right? Direct prima facie link could be seen. Could be seen. Could be seen. Therefore, 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 the connection of the accused applicant with the aforesaid or aforesaid accused two accused persons from whom the contraband materials were seized cannot be ruled out at this stage. Full stop. In view of the aforesaid, the instant bail application is rejected at this stage. No case. You have materials against him.
That is lordship. Not affair case 9, my lord. Here, my lord, allegation is that, my lord, I assaulted my husband, my lord, and subsequently, my lord, he was hit, my lord. Case 9 is the affair. Like, as per affair, my lord, I assaulted 110-12, my lord, and he was taken to hospital 15.
1 second. So what is the medical report?
As per PM report, my lord, there are six injuries, but all are laceration injury, my lord, on knee, wrist joint, left elbow, nose. These are the injury, all lacerated injury, my lord. And but final opinion is keep pending till the Visara has been sent to DFSL, my lord, that is not yet received.
And how he died?
Malad, actually, Malad, as per the statement of witnesses, Malad, there are 4-5 witnesses. They all said that Malad, they have not seen that the petitioner and his brother had tortured. That is not there. And she, in her statement, stated that he is a drunken person. Some altercations took place, Malad, some assault was there, Malad. And due to Malad, heavy consumption of alcohol, Malad, he died. So that regarding final outcome is not yet available because that that FSL report is not available.
But like her statement says that like she must have killed him. She said he is a wicked person, and for which his family member had ousted him.
But
Then she says that in order to protect herself, she pushed her. So she's admitting.
Yes, these six injuries, these are all lacerated injury, but regarding the final opinion is keep pending. Madam, may peruse the PM report. Her statement is there, Malad. Her statement, Malad, may peruse her statement.
You give it to me.
Yes, yes. Some altercations is there, some scrapple is there, Malad.
But my lord, 110, my lord, alleged occurrence on 110, my lord, but he was taken to hospital on 15.
Only because your husband is a wicked person, you killed him.
He was taken to hospital, my lord, and
In
he
the
was
first
died
page
on
itself,
18.
Malad, 6 numbers of injury, first page itself, Malad.
Deep assault is there, my lord. Why, my lord? 5 days was late, my lord, to take to hospital.
He should have taken now to the hospital, being a wife.
5 days, my lord, he was taken to hospital.
No, you being the wife, you should have
Because
taken him.
No such injury was there, that is why. With 67 days in custody with her, my lord, 2 years old child, my lord. I have annexed the birth certificate, my lord. And she has also, my lord, 7 years old daughter also.
Or Mr.
S.H. Sikdar, my lord.
S.H. Sikdar. Nothing is there. S.H. Sikdar, the learned counsel appearing for the accused applicant, also heard Mr. PROCEED, the learned APC for the state. It is an application under so and so. An FIR was lodged by the brother of the victim, alleging FIR was lodged on 18/12/2025 by the brother of the victim, alleging that the accused applicant have assaulted his brother physically, whereby his brother got seriously injured and later on died in the Gauhati Medical College Hospital on 18/12/2025. On receipt of the FIR, police registered Jagirud PS case number 313/2025 under sections 313/3 in bracket 5 BNS 2023. The accused applicant was arrested on 19/12/2025 and since then she is behind the bars. Full stop. The learned counsel appearing for the accused applicant submits that that the victim person was the husband of the accused applicant and is a habitual drinker who used to come home drinking and in the habit of assaulting the accused applicant. He submits that during such assault on the fateful date, uh, the accused applicant pushed him, whereby he sustained certain injuries and he had to be taken to the hospital. And thereafter, due to his alcoholic nature, he succumbed to he expired in the hospital. Full stop. He submits that the accused applicant is a lady having a child, a minor child,
I know, 2 years.
having a two years old child, and she's already inside the jail for how many days?
67.
67 days, and therefore taking into account the length of detention as well as the nature of offense as alleged, this court should allow her to go on bail. Full stop. The learned APP, on the other hand, learned APP has produced the case diary before this court, which shows, which reveals that the victim suffered only minor injuries when he was taken to the hospital. However, he expired later on for expired later on. Full stop. The postmortem report reveals that the final opinion of the cause of death could not be given at this stage as FSL report was awaited. Full stop. Taking into account the whole aspects of the matter in entirety and on perusal of the case record, as well as taking into account that the accused applicant is a lady having a lactating child, this court is of the considered opinion that at this stage the accused applicant should be granted bail. Accordingly, it is directed that the accused applicant shall be released forthwith from jail on furnishing of a bail bond of rupees 30,000 with a surety of like nature to the satisfaction of the
Learned CGM Morigaon.
learned CGM Morigaon, subject to the following conditions. Well, subject to the condition that the accused applicant shall cooperate with the investigation and shall not try to influence any evidence, witnesses that may be involved in the instant case. In next para, in terms of the aforesaid order, aforesaid direction, the instant bail application is disposed of.
Hello.
To be sent back.
May please illustrate. Two petitioner before this honorable court, my lord. FIR at page number 16.
Commercial quantity,
No, my lord,
My lord,
intermediate.
intermediate quantity, my lord.
2 days, 50 days, they are.
how much?
50 days.
Quantity, how much?
Quantity, my lord, 27.99 grams.
Heroin,
Heroin. Page number 19. Inventory.
from your possession.
From both the petitioner.
Hmm?
From both the.
My
The
lord,
reason.
from the petitioner number 1 possession, my lord,
Hmm.
then thereafter on the basis of the, my lord, his, my lord, interrogation statement, then my lord search the other one, my lord. Then thereafter, my lord, recovered, there is another quantity 3.7, something.
3.7 and
Yes,
thing.
my lord. Now, my lord, kindly peruse the CD because there is.
And you are inside the jail for how many days?
50 days.
Huh? 50 days.
My lord, only because, my lord, here in this case, my lord, there's my lord, investigating agency, police, my lord, filed a, my lord, categorically bail objection prayer, my lord, stating that, my lord, these two petitioners, my lord, I have in the, my lord, that the first page, my lord, that objection is there, my lord.
Hmm.
They have, my lord, earlier, my lord, that is, my lord, some other cases also pending in different related to NDPS in both the petitioners, my lord.
Mm.
So at this stage, because, my lord, the 60 days is the period, my lord, to file the charge sheet. Yet, my lord, that is not completed. Only prayer is that, my lord, because, my lord, there are from the interrogation statement, other people's name also come out, my lord. If they, my lord, at this point of time, they will be released, my lord. The my lord, that is the, my lord, investigation will hamper. My lord, may kindly peruse the, my lord, that is the
Now, how many days?
Today
40?
50 days.
50 days. Where is the note?
My lord, in the, my lord, there is objection, my lord, that is clearly stated. In the CD also, this is, my lord, available, my lord. Mubarak has more cases, my lord, that is the accused petitioner number 2, and Kader has 1, my lord. The petitioner number 1.
Mr. Counsel, the allegations are serious against him.
The other cases, my lord, all the cases has been in
Hmm?
intermediate quantity and small
No,
quantity.
intermediate quantity doesn't mean that like you have a unfettered right to get bail. The materials has to be seen. Only section 37 NDPS will not be applicable. There are serious allegations against you. At this stage, it will be difficult.
Then, my lord, after, my lord, 1 week.
You want to withdraw, then it's fine. Otherwise,
After 1 week, maybe.
no. That way we will not keep it. Heard, Mr.
H.A.
Heard, Mr.
H.A. Ahmed.
Mr.
H.A. Ahmed.
H.A. Ali.
H.A. Ahmed.
H.A. Ahmed. The learned counsel appearing for the accused applicant. Also heard Mr. K. Boissa, the learned APP for the state. This is an application on the section, you write it, huh? So. An FIR was lodged. On 6/1/2026. Alleging inter alia that on receipt of an information on 5/1/2026, 26, received an information that the accused applicant was who has been involved in smuggling of NDPS substances was preferring to sell a huge quantity of heroin, the police team The police team went to the spot and apprehended the accused applicant. It was alleged that during apprehension, though the accused applicant wanted to flee, but she was successfully detained, and thereafter on search of therefore on search of the body of the accused applicant, the police recovered suspected heroin amounting to how much?
27.99.
27.99 grams of heroin. Full stop. On receipt of the FIR, police registered Disney PS case number 5/2026 under section 21 small b stroke 25/29 of NDPS Act. The learned counsel appearing for the accused applicant submits, charge sheet not filed, no?
Such not filed.
Learned counsel appearing for the accused applicant submits that that he is already behind the bars for how many days?
50 days.
Hmm?
50 days.
50 days, 50 days. And the quantity recovered is only, quantity recovered is an intermediate quantity. Therefore, at this stage, the accused applicant should be granted bail. Full stop. The case diary in the instant case has been produced before this court, which has been perused. Full stop. On perusal, it is seen that during investigation, it is found that the accused applicant is involved in habitual smuggling of contraband substances, and he has been caught red-handed while he was carrying the aforesaid contraband material. This court, after finding prima facie material of involvement of the accused applicant in the instant case is of the considered opinion that at this stage, the accused applicant should not be granted bail. Accordingly, the bail application is rejected.
33.
In this case, when a diary was called for, my lord,
Well, CD not received, my lord. We pray for short accommodation.
CD not received.
otherwise, what are the cases of the non-following of the Article 21?
Let CD come, then we'll see. CD not, Mr. Anjay Dr. Learned Counsel is present for the accused applicant. Mr. K. Boyce, the learned APP for the state. Case CD not received, let the matter be fixed on
9 or 10, but
9 or 10 full, Mr. Dr.
then there are. Can it be on 16, my lord?
17th will fix.
17.
17th.
But I'm open.
Deeply open.
May it please your receipt. Item number 50 and 51 of same FIR lordship.
Hmm.
In this matter, on the last date, amicus was appointed, madam, we have served a copy to her lordship. And in this case.
You are ready? Madam, you are ready?
My lord, madam, may kindly be time being, my lord. Mr. Parasar is on legs in another court. Only just time being.
Okay.
He's coming.
Thank you.
52.
$52.
Same FIR, no? Same FIR. Together.
53.
The regular bail application lordships. It is on behind for last 56 days lordships.
Hmm.
Intermediate quantity lordship, page 13 is the affair lordship, page 14 is the operative part lordship.
Yes.
Nothing recovered from the possession of the petitioner lordship, only one mobile phone and one knife has been recovered from his possession lordships. Page 14 lordships, operative part lordship,
Case 14.
14 lordships. 56 days.
How you got implicated? How did you get implicated?
Actually, lordships, as per allegation lordship, the accused number 1, Sultan Ali,
Hmm.
is going to sell the
my lord, contravened to the petitioner lordships.
So they obviously, no contraband will be found in his possession because
But
he was going to sell only. It was not sold.
As per allegation lordship, no.
It was not sold.
So, yes, lordship, that is not the done lordship. It was arrested from my house, in front of my house lordship.
Yes.
I got three lordships.
You will not
And
be
today's-
arrested from Thailand. You'll be arrested from your house only.
There is 56 days behind our lordship. Only 13 point, something gram.
Yes, Mr. Boiso, what is there?
My lord, CD not received, my lord.
She will not receive.
Well, today's third date lordship.
Hmm?
Earlier two dates lordship, she did not receive today. That's why you also.
Intermediate quantity 60 days.
Lordships. Today.
60 days.
And on day before yesterday also case was listed lordship. That's why before your lordship, and your lordship was pleased to fix the matter today itself lordship. Well, kindly 56 days lordship. Kindly consider my random detention lordship.
56 days, okay, case there will come, it will be, already time will be over.
Lordship.
Heard Mr. M. Hawk, the legal counsel appearing for the accused applicant, also heard Mr. K. Boiso, learned APP for the state. This is an application under so and so, that an FIR was lodged on. Now, otherwise you write like this, the prosecution story in gist is that on 30/12/2025, 25, a secret information was received about a drug peddler at Agiathuri and one Dilnur Ali. You are Dilnur Ali.
Lordship.
One Dilnur Ali was to receive the same. On the basis of the aforesaid information, the police party conducted you don't write, the factual part also properly. Just you have to file the bail application, you file it. At least the factual part which has been stated in the FIR, you can put it little bit, elaborately so that it becomes easier for the court to pass the order. But you don't do it. So court has to go through the whole FIR, then they'll have to summarize it. So it takes time, right?
sorry.
So it should make it convenient for
I'm
the
sorry.
court so that you get an early order.
Next time
So if you get an order 10 minutes before also you'll be more happy, right?
I'm sorry, Lord.
The police reached Agiathuri near Ganesh Mandir. And they approached two accused persons, namely Wahidur Rahman and Rintu Ali. On being apprehended, one soap box containing suspected heroin was recovered from the possession of Sultan Ahmed. Sorry, don't write these two names. There's Wahidur Rahman and this. Don't write. Write Sultan Ahmed and Dilnur Ali. Dilnur Ali. Then you write that the police recovered one from the possession of the Sultan Ali and one knife from the possession of Dilnur Ali. On receipt of the FIR, police registered. Aju PS case number 539/2025 under section 21B/29 of NDPS Act. Stop. The learned counsel appearing for the accused applicant. submits that the accused applicant has been arrested on on the very same date as mentioned in the FIR, and he is behind the bars for last 56 days. He further submits that nothing suspicious was recovered from his possession, and whatever the contraband materials, suspected contraband materials recovered were from the other co-accused person, namely Sultan Ali. Sultan Ali. He submits that he doesn't have any knowledge. He did not have any knowledge of any possession of contraband materials by the aforesaid Sultan Ali. Full stop. He further submits that though case diary was called for on many occasions, but the case diary is yet to be received, and the case diary is yet to be produced. Full stop. He submits that taking into the aforesaid facts, after taking into account the aforesaid facts, this court should allow him to go and bail, as the quantity which was alleged to have been recovered is of intermediate quantity, and that too not from his possession. Full stop. Next paragraph, the learned APP opposes the bail application at this stage. Full stop. Taking into account of the fact that case diary is yet to be received by this court, and the accused applicant is behind the bars for 56 days. 56 days. This court is the considered opinion that at this stage the accused applicant should be released on bail. Accordingly, it is directed that the accused applicant shall be released forthwith on bail on furnishing of bail bond of rupees 50,000 with a security of like nature, subject to the satisfaction of the special judge. Special judge Kamrup Amingaon, subject to the following conditions: that the accused applicant shall cooperate with the investigation in the instant case and make himself available as and when called for by the IO. Full stop. Then the accused applicant shall not try to influence the evidence or witnesses that may be involved in the instant case. Full stop. In terms of the aforesaid direction, the instant bail application is disposed of.
Timing items 50, 51, and 52.
52 is
Only 50 and 51.
52 is different. 52 is different.
Only 50 and 51.
50 and 51.
50 and 51, yes.
The FIR is a page number, my lord, the operative page number 17, let's say type copy. The petitioner is in custody, my lord, today is 308 days, let's say, in custody, my lord.
308 days.
In custody, lordship. For POSCO is there, lordship. FIR is at page number, my lord, 17.
Page number?
17, lordship, type copy.
Yes.
May I read, lordship?
Yes.
My lord, search sheet was submitted on, my lord, 17/25, my lord.
Page?
Page number 24, lordship.
24.
Yes, lordship, 24 onward, my lord. In page number 30, lordship, age of the accused victim, my lord, recorded as 17 years, 5 months, 11 days, my lord. My lord, and now, my lord, trial is going on, lordship, and statement of informant and the victim girl also recorded, my lord. So, my lord, I am praying that I may be given some opportunity to defend myself, and already 309 days, lordship. He is also 19 years old, lordship. Well, additionally, one submission is that, my lord, section 47 and 48 of the BNS was not substantially complied with, lordship. The grounds of those stated, my lord, not properly explained, lordship. I have annexed the, my lord, notice under 47, my lord, page number 22 and 23, lordship. Though grounds of race was stated, my lord, but not properly explained, lordship. Moreover, my lord, The 23 and
Yeah,
24.
Mr. Parasar, those are complied, I mean,
Yes, Lord,
substantially
more,
complied.
my lord, he is 19 years, my lord, not well conversant with English, my lord. The ground base was not communicated in his language, he understand, lordship. As per Hiranjan, my lord, Sah, my lord, ground base may be communicated in the ground, in the language he understand, lordship. That is also, my lord, not properly complied with, my lord.
Yes, Mr. Parasar,
My lord, 309 days, lordship, some opportunities to defend himself, my lord. He is also 19 years, lordship.
My lord, that boy is 19 years and he's from same village, same village. Girl is at the time, my lord, 17 years, 5 months. And my lord, forceful physical is there, my lord, as per her statement in 183, as well as her my lord, evidence as PW1. Now,
and what was the reason are not disclosing?
not disclosing out of fear, my lord, at that point of time, her brother was in hospital in critical condition, my lord.
Mm.
At that point of time, nothing, no one is there. And my lord, in that situation, my lord, he has committed rape first time, my lord, subsequently 2-3 occasions that is happened. And out of fear. Now again another person, my lord, page item number 51. Gaurikanto.
Yes.
He is one distant relative, my lord. He saw my lord, the girl and the boy in one time.
So he took the, I mean,
Advantage and blackmailing. He also, my lord, physically, my lord, physical relation is there, my lord. He against the my lord, person in item 51 2 times. And subsequently the girl became pregnant. As per the my lord, medical report, my lord,
Mr.
5 to
Rahman,
6
right?
weeks.
It will be difficult now.
My
At
lord,
this stage.
at least
Okay, let me have a
item
look.
number 50, lordship, and that may be considered, lordship, instead of 51, lordship. Considering his age, my lord, then well, already 309 days, my lord, and informant and the victim have already been recorded, lordship. So there is no chances of any, my lord, threatening or.
Oh, at this stage, really difficult. Let me see. I mean,
Medical evidence shows, my lord, 5 to 6 weeks pregnancy is there. My lord. And this regarding this item, my lord, 51.
Hmm.
He is a person of, my lord, around
he's an old person. Old person means like
49
he's.
years.
Hmm.
And he took the advantage, my lord, as per the statement of the boy also, my lord. At least that doctor's evidence not yet, my lord.
My lord, 13 witnesses are there, my lord. Trial may take some time, lordship.
My lord, may peruse the statement.
Okay, it's all right. I mean, it will be difficult at this stage.
Well, at least for the
No.
at number 50, lordship.
No. It will be difficult.
Hard,
Mr. Hard, Mr. S. Rahman.
H. Rahman, lordship.
H. Rahman. The learned counsel appearing for the accused applicant also heard Mr. K.K. Parasar, learned APP for the state as well as MS. S. Bora. MS S. Bora, the amicus curiae for respondent number 2. Full stop. This is an application under so and so. Right. An FIR was lodged on 22/4/2025 by one Babu Varali, alleging that when his minor sister, due to certain gynecological problems, visited Gauhati Primary Health Center for treatment, on examination, she was found to be carrying a pregnancy of about 2 months. It was alleged that subsequently an ultrasound was conducted at a nursing home in Sibsagar and report revealed a positive pregnancy of about 2 months. It was alleged that when police produced his sister before the Child Welfare Committee, she allegedly stated that the applicant and another person had committed forceful sexual intercourse with her, and as a result of which she became pregnant. First of on On receipt of the FIR, next paragraph, on receipt of the FIR, the police registered Gauhati PS case number 15/2025 under the aforementioned sections. On completion of the investigation, charge sheet number 19/2025 dated 17/6/2025 was submitted by the investigating officer, wherein 13 persons have been named as PWs. Full stop. The accused, next para. The learned counsel appearing for the accused applicant submits that accused applicant is behind the bars for last 308 days, and he is a boy of 19 years. Full stop. He further submits that further submits that none has been examined till now.
Informant and victim examined.
Submits that since the informant and the victim girl has already been examined before the trial court, there is no requirement for any more custodial detention of the accused applicant at this stage. Therefore, he should be allowed to go on bail at this stage. First step. Accused the KK PROCEED and APP. On the other hand, submits that there are materials, prima facie materials available implicating the accused applicant of committing the offense as alleged in the FIR. He submits that the trial is going on a reasonable speed and it is expected to be completed in a reasonable time. Therefore, at this stage, that the accused applicant should not be granted bail. His submission has also been supported by the learned amicus curiae appearing for the respondent number 2. This court has gone through the materials brought before this court as well as heard the submissions made by the counsel appearing for the respective parties, taking into account the fact that that a heinous crime has been committed by the accused applicant, and there are other prima facie incriminating materials against the accused applicant, who is a neighbor, who is a villager of the same village of the accused, some village of the victim girl. This court is of the considered opinion that at this stage, the bail to the accused applicant should not be granted. Accordingly, the instant bail application is rejected. Number 2, item number 51. 51 facts will be same, huh?
But he is a person of Malat.
49 years old.
49 years old.
The facts will be
Distant relative of the.
all others you keep same, okay? Only right during the investigation, it was found that the accused applicant, after coming to know about the sexual relationship between the accused, between the co-accused and the victim girl, he took the opportunity, who took the advantage and committed sexual intercourse with her, and thereby the victim girl got pregnant. इतना लिखो, बाकी एक ही होगा. खाली वो submissions में खाली लिखना ये 308 days pass हुआ है. At this stage it is difficult.
Item 52.
Who is appearing? None appeared when the matter was called for.
Service report also awaited, as per official.
None appeared for the applicant when the matter was called for. Let the matter be listed on 18th March.
For 34 bail hearing.
34. 34, 34, yes. Charge sheet submitted, my lord.
Nobody is appearing in the matter. Last occasions also.
Charge sheet submitted, my lord, maybe close, my lord. Last occasion also not.
Mhm. None appeared for the petitioner accused applicant when the matter was called for. It is seen that previous three occasions also none appeared for the accused applicant when the matter was called for. The learned Mr. K.K. Palasu, the learned APG, has submitted the charge sheet in the instant case has already been filed by
Case number 99/2025, dated 5/6/25.
25. In view of the aforesaid, submission, this instant AB application is closed and disposed of.
35.
May it please your lordship. Anticipatory bail application, interim prayer was allowed. FIR is at page number 13, CD was called for.
My lord, in this case, my lord, charge sheet has been submitted, my lord.
Go and appear there.
Will appear.
Heard Mr. T. Loskar, the learned counsel for the accused applicants, also heard Mr. Arjit Burwa, the learned APP for the state. Then you write, this is an application. Then you write, the case arose out of an FIR dated 18/9/2025 lodged by the police official of the aforesaid police station, naming all the 4 accused applicants in the FIR and alleging that there was an information about illegal sale of cow meat from the area. And on 17/9/2025, a raid was conducted, whereupon, 25 kgs of suspected cow meat was seized in the name of the 2 witnesses have also been mentioned. Seized and 2 witnesses have also been mentioned. The learned APP submits that the charge sheet in the instant case has already been submitted by charge sheet number.
Charge sheet number, my lord, 260/2025, dated 31/12/2025.
24. In view of the aforesaid, the learned counsel submits that we should be allowed to take appropriate relief in the appropriate forum. Full stop. In view of the aforesaid, the instant AB application is closed and disposed of.
57.
37, my lord, case there is no discipline.
CD not, Mr. S. Bora, the learned counsel is present
He's
for
on
the,
interim, man.
for the accused applicant. CD, it is yet to be received. Interim order so passed earlier is extended till the next date of listing.
Date, my lord, 16/3, my lord.
Oh, sorry, let the matter be listed on 16/3, yes.
38.
38 case there is received, my lord.
May it please your lordship.
Hmm.
Well, FIR at page 10. Done. Well, the allegation is that, my lord, some cattle were, my lord, seized, my lord, and driver was arrested, my lord.
You are who?
But I am the person who has been alleged that I helped the driver to flee from the place, my lord. But on the contrary, my lord, the number of the cattle were given to the owner of the cattle. And my lord, the driver was arrested from the spot itself, my lord.
Hmm.
So my lord, I'm neither the owner of the cattle nor the owner of the truck. And my lord, these cattle were, my lord, later on, my lord.
I mean, how you got arrested?
No, I'm not arrested, my lord. This is pre-arrest
Oh,
bail.
sorry, this is PRS bill.
Pre-arrest bail, my lord.
Hmm. And I mean, how you got implicated?
But that, my lord, I helped the driver to flee from the place. That is the allegation against me.
Yes, Mr. Burwa.
And my lordship may see, I given an order, my lord. The cattle were already handed over to the owner of the cattle, my lord. So the question of these are not stolen cattle, that is a different, and the Lordship, I am annexed the forwarding report of the driver,
What is, Mr. Boro, what is the allegation against him?
The allegation against him, my lord, the driver of the vehicle, my lord, he carried, my lord, 32 numbers of cattle in his vehicle, my lord, in his truck, my lord. Then truck goes some, my lord, mechanical problem, my lord.
Then,
it was stopped, my lord.
yes.
Then, my lord, there was another person, my lord, who was also along with the, my lord, cattle, my lord, in the truck itself. Then, my lord, when he went to, my lord, find some mechanic, my lord, then allegation is that this person, my lord, Hafizuddin, he came and he tried to, my lord, he has helped this other accused person who was sitting in the vehicle, my lord, fled away from the, my lord, place, my lord. Later on, my lord, it was informed to the police, my lord, and police has come and police has, my lord, seized all the 32 numbers of cattle, my lord, along with the vehicle, and driver was also arrested, my lord.
But cattle have been given Jimma to the original owner of the cattle, These are not,
And allegation is that, my lord, cattle was not brought, my lord, in properly, my lord. There was no food, no water. These are the allegations.
But Jimma has been given already. Heard Mr. A.S. Abdullah P. the learned counsel appearing for the accused applicant. Also heard Mr. Arjay Boro, learned APP for the state. A reason application under so and so. The allegation as alleged in the FIR against the accused person is that while rescuing 35 numbers of cattle from a vehicle at Burapa and at National Highway 715 near Burapahar Bridge, the accused applicant tried to help the driver of the vehicle to flee away. Full stop. Full stop. On receipt of the FIR, the police registered Jakhalabanda police station case numbers 07/2026 under the aforementioned section. Full stop. The learned counsel appearing for the accused applicant submits that the cattle were in fact given Jimma by the appropriate court by the SDGM, by the court of SDGM, Koliabor, Nagaon, by 7/2/2026, after finding the cattle to be, duly purchased and owned by the owner of the cattle. Full stop. Full stop. He submits that the allegation against the accused applicant is totally false. And those cattle were in fact duly purchased, and as those cattle were found to be, don't write cattle, write cattle. Cattle were found to be duly legally purchased. There should not be any allegation against the accused applicant of awaiting any crime. Full stop. Therefore, he submits that the accused applicant should be granted pre-arrest bail, and he submits that he will fully cooperate with the investigation. Full stop. Taking into account the entire facts of the case, as well as on perusal of the case diary, this court is of the considered opinion that at this stage the accused applicant should be granted the pre-arrest bail. Accordingly, it is directed that in the event of arrest of the accused applicant, he shall be released on bail on furnishing of a bail bond of ₹20,000 with a surety of same amount to the satisfaction of the SDGM Koliabor Nagaon.
Arresting authority.
Arresting authority. Arresting authority, subject to the following conditions. Number one, you write that the accused applicant shall appear before the investigating officer within a period of 10 days of passing of this order. Number two, you write the accused applicant shall cooperate with the investigation and make himself available as and when called for. Number three, accused applicant shall not try to influence any witness that may be involved in the instant case. In terms of the aforesaid direction, the instant AB application is disposed of as allowed.
39 and 40. 39 and 40, my lord, they are on interim, my lord. Case diary not received to them.
Case diary not received in both cases. interim order so passed earlier shall continue,
18-3.
shall continue till the next date of listing, that is 18th March 2026. Both the cases, huh?
41.
May please allow. Anticipatory bail application.
My lord, in this case, my lord, the two cases there was called for, my lord. The concerned PS case is, my lord, testful PS case number 766/2025. And another, my lord, cross case is 764/2025. We have received the case diary of, my lord, 764, the cross case, my lord.
But
Main case was received, my lord.
he is already in
My lord,
interim.
what had happened was, when.
But you are already in
Well,
interim, no?
just one submission, my lord. On the date when I went to give the interim bail order,
Mm.
police arrested me. What had happened, my lord, there were two FIRs.
Mm.
First FIR was lodged by us.
Mm.
That was registered as 764, in which case diary was come. Subsequently, another FIR was lodged against us, in which this honorable court protected us and gave us interim protection.
Mm.
We took the interim bail order on 4/2/2026. We went to the police station, then found out that the other party had lodged another FIR against us, in which police arrested us. Now we are in custody.
Or that they have to file separate bail
But
application.
I understand, my lord. I'll file. Just pointing it out to your lordship, my lord.
Okay, then I will not mention anything. I mean, CD not received in the instant case. CD relating to which case? Case
My lord,
number
It is relating to, my lord, testful PS case number 766.
is received, not
Is-
received.
Is not received. my lord.
Right, right.
That is the
CD,
concerned case.
CD relating to CD in connection to case
Testful
number
PS case number 766
Oh.
public 2025.
25 is not received. Let the matter be fixed on, fixed on,
They are on interim, my lord, in this case.
17th March, interim order so passed earlier shall continue till the next date of listing.
I'm deeply.
53.
Next date, my lord, on
17th.
17.
I'm deeply. Okay.
Even 40. 43, Dipta, keep very. তোমার নাকি 43?
Case diary come.
43 case diary come বলে।
My lord, one
Put to the-
executive statement has been recorded, my lord.
My learned friend has gone through, my lord. I told you. This is the time.
Just see the case diary.
Madam, kindly be time being just, but 2 minutes, my lord.
No, see, I'll see it and like, it's not required.
Statement. Yes. No, statement is not. Interim be accessed. Right. Interim is not there.
Mr. Boyso, there is nothing against him. Heard Ms. MS
And Nasrin, my lord.
Nasrin Madam Council applying to the accused applicant also heard Mr. K. Boyso, Lord, APP for the state. This is an application under section so and so. An FIR was lost on 15/12/2025, alleging missing of the daughter of the informant, wherein it was alleged that accused applicant number one, accused applicant number 1, 2, 3, and 4 induced her, accused applicant number 2, 3, and 4 wanted the girl to be married to the accused applicant number 1. It was alleged that when the informant's family refused the offer, stating that the girl was a minor at that point of time, the accused it was alleged that the accused persons took her to some unknown place. Thereby, the missing report was lodged before the police. On receipt of the FIR, the police registered South Selmar PS case number 171/2025 under section 61 in bracket 2 stroke 87 bracket stroke 3 bracket 5 of BNS. It is seen from the case diary that the accused that the girl on her own returned to her home on the very same date of the alleged occurrence. Full stop. On perusal of the case diary, it is seen that there is no prima facie material against the accused applicants, and therefore this court is of the considered opinion that the accused applicants should be granted the privilege of pre-arrest bail on furnishing of bail bond of ₹20,000 each, with surety of like nature to the satisfaction of the investigating officer in connection with South Salmon PS case number 171/2025, subject to the following conditions. That the accused applicants shall appear before the IO within a period of 10 days from passing of this order. The accused applicants shall not try to contact either the girl or the family members during the investigation of the case. Then you write that the accused applicants shall cooperate with the investigation. In terms of the aforesaid direction, the instant bail AB application is disposed of as allowed.
55 and 56.
Maybe. And this is really based on an annexer 1 minute and there is in the page 10, your lordship can be seen. Very good. When you go 55, let it proceed. As that is very simple, my lord. It is mentioned that
You are coming from Mohiruddin and Abdul Jalil.
Abdul Jalil and Mohiruddin. Yes. 7 and 8.
7 and 8, yes.
7 and 8.
Hmm.
Then with the due respect, the humble submission is there. One last 7 CL 2024 at about 11:30 p.m. on the night, my father was coming toward home from Portugal after attending a religious meeting. The above named accused persons jointly.
So you are accused of killing somebody. Yes, tell me then. Then
and my submission is then my number 1 is about 61, has 2 60 or 6. Both of their assistant teacher of high school.
I'll be also 61 years after maybe 7 years. I'm still strong. I think I'll be strong at that time also when I'll become 61 years of age.
Anyway, my submission is that they are aged 60 and 61 years, they have retired from service. Only the submission is that there is the omnibus statement in the SR. There is nothing mentioned who has killed him, how.
No, you have been named in the FIR,
Only
Mr.
names,
Mr.
only
Rosit,
named in
named in the
submission.
FIR
Yes.
and allegation are serious. What is there?
And kindly say annexed 2 of my.
No, I got it. Anything else?
Medical fees. On the same date, Milan.
No, medical, what medical? I mean, it was, I mean, medical of whom?
That is Milan Abdul Jalil,
Huh?
number 2.
Abdul Jalil. Same day you were somewhere else.
I was ill on the day, Milan. I went to the doctor, Milan, and doctor treated me.
No, you were going to the doctor, you killed somebody.
For me, myself.
No, you went to the doctor. I mean, you were not there at that point of time.
No, and I went to the doctor at daytime, Milan, not night.
So I
But
mean,
then I
so
could
how does
feel
it help? How does it help?
Then I am over,
Mr.
I am suffering from illness. I can, that better also may have argument, I'll.
Okay, who else?
From other persons.
Okay.
56.
I have
56.
full person Lordship, Abdul Alim,
Hmm.
Mizanur Rahman, Azizur Rahman.
Same offense, same crime.
Same crime, but only thing is.
What
that
is your
Lordship,
ground?
We are the cousin of that informant Lordship, we are all relative. And as per my health, these two Lordship, 1 and 2, Kasim Ali and Hasim Ali, they are the stepbrother of the deceased, and they had a long Lordship dispute regarding ancestral property Lordship. And this is the result of that, and we are just incorporate our names in the FIR Lordship. That CD will reveal what.
Yes, CD will reveal, yes.
Malat, yes, Malat, the informant, the son Malat, and Malat, this were coming Malat from the.
Informant, son and the father. Father were coming and like in the, I mean, midway they have been attacked.
Son is a little behind Malat, he's coming Malat. And at that point of time, Malat, total Malat attacked by 6 persons, Malat. All the 4 persons in item number 56, their names were Kasim Ali, Hasim Ali, Mizanur Rahman, Azizur Rahman, Abdul Latif, Abdul Alim. And the persons in item number 55, Abdul Jalil and Mohiruddin, they তেওঁলোকে hospital নিবলৈ বাধা দিছিল. Regarding assault, these 2 persons were not there. তেওঁলোকে hospital নিবতে বাধা দিছিল. And as per postmortem report, there are multiple injury in head, backside, foreign, details has been given with photographs.
And Abdul Jalil and Mohiruddin, they tried to stop the person to be taken to the hospital.
And as per
I mean, all these people are related? Abdul Jalil, Mohiruddin and other Abdul Alim and all these people?
Same village,
No, are you related to these other other accused persons?
No.
You are not related, but you are simply coming along with them.
They are from the same village. From the same village.
Same village, they were coming from some religious function. On the way they met him, but they are not related.
And as per the postmortem report, between injury to death, 20 minutes to 60 minutes, death occurred immediately. And high velocity of impact by sharp and.
Okay, Mr. Munir, it will be difficult at this stage.
Lordship, may I pray one thing?
AB, my lord.
May I pray one thing, Lordship? That the Kasim Ali Lordship, he is already arrested, Lordship. He is suspected to be a prime accused.
Kasim Ali is already arrested.
Oh, Lordship, kindly his statement, Lordship, if once, Lordship.
His statement, see, what is there?
Kasim's statement.
Basically, the fight is between Kasim Ali, Hasim Ali, and
Hasim Ali.
deceased.
Whatever, I mean, like you have been named, I mean,
Lordship, name is given, Lordship. That is why we are here.
you have been named and allegations are there.
Definitely, because for that only we are here, Lordship.
Like, that is why we'll see what is, that is why we'll see.
Kindly, Lordship, that their statement, Lordship, Kasim.
Kasim, no, Hasim to
Hasim Ali.
Hasim Ali too.
Hasim Ali.
Hasim Ali, not Kasim. Hasim Ali is there, yes. I have not seen.
See, Mr. Munir, your initial submission is that you are not, it is not that you are rejecting the whole story. You are admitting that you were there. Only thing you have submitted is that there was some enmity. So thereby you are saying that you are involved in the thing, but,
no,
but,
this-
but,
this-
no, that was your submission.
He also denied, my lord.
But you're saying that like there was some enmity, that's why I mean.
No, so regarding 1 and 2, they are separate person, Lordship.
What is there? What is there?
Hasim also denied, my lord. He মোক দাদা হানিফ আলী কোনোবাই মাৰিছে বুলি মোক ফোন কৰি জনায়. So he also denying. He also said that I am not there. So my lord, their statement, my lord, only saying all this, my lord, it will not happen. My lord, eyewitness is there, my lord, statement. My lord, and my lord, immediately it is.
Let me see the eyewitnesses.
He was arrested, Lordship, that Hasim Ali. No?
Yes.
Let me see that.
But Lordship, their custodial Lordship interrogation and that.
Hasim statement, I'll flag my Hasim. Green flag is Hasim. Others, my lord. Yes, for Azizur Rahman, Abdul Alim, Mizanur Rahman, and Abdul Latif. All are there.
Mr. Munir,
Lordship.
this is not, I mean, one of the arrested persons. The witness is from an eyewitness.
No. Arrested person is there, Lordship. He is.
No. What I am saying is that the statement is coming from an eyewitness, alleging you. It's independent eyewitness. It's not by the one of the accused persons or who has been arrested and who has been tortured in the police custody and he has confessed. Not like that. It is from an independent witness.
And Malat, at this stage, AB.
Heard Mr. But in his case, I think there is nothing.
As per the statement,
He's an old person, two old persons. But you were similar. You were differently situated. Heard Mr. A. Rashid, the learned counsel, appearing for the accused applicants. Yours is item number 56. 55.
আমার তো কিশোর হয় আমার তো
Except applicants. Then also write PK Paras's name. Then it says application under so and so. Then you write.
Lordship, my name is recorded. Lordship. I'm from informant, Lordship.
And also Mr.
SK Chetri. SK Chetri.
SK Chetri, learned counsel for the informant, full stop. The prosecution case in brief is that on 8/12/2025, informant Akbar Ali lodged an FIR at Manechar police station alleging inter alia that on last 7/12/2025 at about 11:30 p.m. of night while his father was coming towards home from Paltan Bazar after attending a religious meeting, the accused applicants along with six other co-accused persons, assaulted his father with sharp weapon on the road in front of the house of the accused applicant, in front of the house of accused number one, that is one Qasim Ali, causing serious injury to him. It was alleged that on inter alia লিখিছে ন আগত inter alia লিখিছিলে ন লিখিছে semicolon দিয়া that upon hearing hue and cry of the informant and others, cry of the informant, the other people, the neighboring people came and found the informant's father lying on the ground in a pool of blood. Consequently, he was taken to the hospital, to a hospital in Abhayapuri, and thereafter he was referred to Bongaigaon Hospital, wherein the person was declared dead. On receipt of the FIR, police registered Manechar police station case number 45/2025 under the aforementioned sections. The learned counsel appearing for the accused applicant submits that both the accused persons are elderly people aging about aged more than 61 years, and they were not involved in assaulting the accused, assaulting the father of the informant. Full stop. Full stop. He submits that in fact the accused applicants were returning from returning from a religious function and had been accompanying the other co-accused accused persons, and on reaching the place of occurrence, they found suddenly the co-accused persons assaulting the informant's father. The accused, the learned counsel submits that the accused applicants the appeal applicants do not have any criminal antecedents, and they will fully cooperate in the investigation. In the instant case, therefore, they should be allowed to go on bail. Next para. The case diary in the instant case has been produced before this court, and the same is on perusal of the case diary. There is no material found about the involvement of the accused applicants in the instant accused applicants in the alleged offense as alleged in the FIR. Therefore, this court is of the considered opinion that the accused applicants should be granted the privilege of pre-arrest bail at this stage. Full stop. Accordingly, it is directed that in the event of arrest of the accused applicants in connection with the aforesaid case, the accused applicants should be released on bail on furnishing of bail bond of ₹20,000 with a security of like amount to the satisfaction of the arresting authority, subject to the condition that the accused applicants shall appear before the IO within a period of 10 days and fully cooperate with the investigation. In terms of the aforesaid order, aforesaid direction, the instant AB application is disposed of. Right, the next one. Episode ID. Episode ID. Facts are heard right, Mr. S. Munir, the learned counsel appearing for the accused applicant. Accused applicants submit that the FIR has been lodged falsely and due to certain enmity between the family of the informant and the accused applicants. He submits that the accused applicants were not involved in assaulting the informant's father. He further submits that the accused applicants are ready to fully cooperate with the investigation in the event of the accused applicants are released. Applicants are granted the privilege of pre-arrest bail. Full stop. The case diary in the instant case has been produced before this court. On perusal of the case diary and after finding sufficient incriminating materials against the accused applicants, the instant bail AB application is rejected at this stage.
Much obliged, Your Lord. Much obliged.
Bail hearing खत्म नहीं है जब हम पाहुंकल उनको लिए
For admissions.
The criminal division against the interim order of interim maintenance.
we'll fix it some other day.
Yes,
Huh?
Lordship makes some.
On the prayer of the learned counsel appearing for the respective parties, let the matter be fixed on.
Interim order may be extended, Lordship.
Let the matter be fixed on sometime on 19th.
19 March.
19 March.
Yes.
Fixed on 19 March. Interim order so passed earlier shall continue till the next set of listing. Respondent number 2 is there? No.
No,
Uh,
not, respondent two is there, my lord, female
And
petitioner.
then nobody is appearing.
No, no is appearing. My name is has been shown, my lord. KK Henrik and
That's what, nobody, your name,
D.R. Ahmed, appearing on behalf of Darakullah.
your name,
D.R. Ahmed,
AR,
D.R.
MSDR Ahmed, the learned counsel appearing on behalf of Diullah is present for the petitioner. Mr. KK Parasar, APP is also present. However, none appeared on behalf of respondent number 2. Full stop. In the interest of justice, let the matter be fixed on 20th of December, 20th of March.
Much obliged.
TCR was called for, that is not available. Informant appears.
TCR not received.
PCR not received, my lord.
Mr. NJ Doctor, the counsel for the petitioner is present,
State, yes.
as well as Mr. KK Parasar, learned APP for the state. Full stop. Arya Ahmed for respondent number 2. TCR in the instant case is yet to be received. Let the matter be fixed on
Interim is there, my lord.
interim orders of first early shall continue till the next date of listing. Let the matter be fixed on 19th March.
I think 12.
May I please, Your Lordship? Respondent appear, but today they are not available.
Okay, heard Mr. H. A. Ahmed, the learned counsel appearing for the accused applicant, also heard Mr. KK Parasar, learned APP for the state.
Yeah, TCR received.
Somebody appeared earlier.
Earlier appear, my lord.
Alamgir name, who's the name shown? my
Name
lord?
is shown.
Name
Name
shown
is
in the-
shown, my lord.
S. Salim, no? However, none appeared for the respondent number 2. Case they received. Oh, sorry,
Yes,
TCR received.
TCR received.
TCR received to be retained. Let the matter be listed on
27, my lord.
on 23rd March. 23rd March. Okay.
My lord, 23rd, some difficulties on the
24th.
last.
24th.
There's item 44.
Last provision, honorable court has directed to me to take a fresh step with the additional public prosecutor, madam. We take a step today, step, madam, through public prosecutor. We have taken a step today, step, madam.
Today you have taken this
Yes,
step. The learned counsel appearing for the petitioner.
F.A. Hassan.
F.A. Hassan, the learned counsel appearing for the petitioner, submits that they have taken fresh steps today itself. As per the order dated 222026, let the matter be listed on 24th March,
21st,
24th.
24th, obliged rule.
45.
Based on IA for delay condemnation lawsuit, criminal review petition lawsuit.
How many days?
Lordship,
Who are the parties?
lordship, sole respondent, lordship.
She's not there.
Lordship.
Notice is issued.
Notice was issued, lordship.
So we'll wait for some time, Mr. Bhagwat.
Lordship.
Nobody is appearing.
Lordship.
How many days were there?
Actually, lordship, although it has been recorded as 144, but in all practical purpose, it is 40 days, lordship.
40 days.
Because initially I had filed a criminal appeal, lordship, but that for intellectual application, that won't lie. So after the delay was unknown, I myself
Withdrawn then.
lordship.
Okay, let her be there. I mean, let somebody be there. Okay, heard Mr. M. Bhagwati, the learned counsel, appearing for the petitioner. Appearing for the petitioner. None appeared for the sole respondent. I'll stop. In the interest of justice, let the matter be fixed on on 23rd March. We'll do
Lordship.
on 23rd March. IA and this thing both, huh? Right.
Achho.
46.
On last,
One I know, the, oh, criminal, one I know, yeah. Delay consent.
Lordship, on last occasion, the TCR was called for.
TCR is here.
TCR is there. So Lordship may kindly fix it. for the-
TCR in the instant case has been received, let the parties are duly
No,
represented.
respond number
Parties are due, huh?
Respond number two, my lord, two is there.
Two is not there.
Two is there, my lord, none is there.
Okay, Mr. W.R. Bedhi is present for the, for the petitioner, as well as Mr. K.K. Parasar, learned APP for the state. However, none appears for the respondent number two. For the interest of justice, let the matter be listed on 24th March,
Lordship, on 24th is the next date, and in that particular.
23rd March.
23rd, 18 if possible, Lordship, 18 or 19. If possible, if can accommodate. 18 or 19. If not, then 20.
18, 19, lot of cases in mix, 18, 19.
Then 23rd, Lordship.
There will be on 23rd, yeah. 23rd.
Oblige.
57.
May I please, Your Lordship? Madam, we have taken step for public prosecutor office, madam. Respondent number.
Respondent number.
47, on to, my lord, steps as per, my lord, record, they have taken steps on, my lord, 18, and it was sent from our office, my lord, on 20. Today is 25, my lord, we will, my lord, we have to take instruction, my lord, regarding.
Learned counsel, yeah, Mr.
SM Molla, madam.
SM Mohammed.
SM Molla, madam.
SM Molla, the learned counsel appearing for the petitioner, submits that he has taken steps for service of notice on respondent number two. However, it is seen that no report of service of notice on respondent number, on respondent number two is yet, is received. Let the matter be listed on
Lower court date is on 3rd of March, madam.
3rd of March. So before that, it's not possible.
3rd of
You have not,
March.
how can it be?
Most probably holiday, my lord, due to.
But anyways, I mean, like, we'll put it on, 25th March. 25th March,
Madam, he is absconding, madam. He was shown absconder in the charge sheet, madam.
can't be helped,
Madam, possible little bit earlier.
can't be helped.
Kindly,
Criminal petition, who is absconder?
petitioner before your lordship.
You abscond and like, I will
Madam,
put it
during
there.
pendency of my bail application, charge sheet has been filed, my lord, showing him absconder. Therefore, we filed.
You are absconding, you surrender.
Madam, They are there, my lord. We may be taken into custody because.
I mean, you'll have to, see, you'll have to cooperate with the investigation.
Definitely
Now,
my-
since charge sheet has been filed,
My lord.
I mean, what is to be done? We can at the most put your case on 19 March. 19 March, so many cases. 19 March, 19 March.
And for the petitioner.
You are ready to do hearing?
No, Lordship, respondent side is not there, Lordship.
Okay, Mr.
M. Hussain on behalf of.
M. Hussain, on behalf of
R. Ali.
R. Ali is present for the petitioner. However, none appeared for the respondents when the matter was called for. For the interest of justice, let the matter be fixed on
After 4 weeks.
20, on 15th, on 30th of March. 30th March. 30. Only.
Okay.